The Rules Committee will come to order. We are here for the consideration of two measures, the Protecting Jobs from Government Interference Act, H.R. 2587, and Senate Bill 627, which will be amending a Senate amendment for consideration of the Budget Control Act of 2011. We'll begin with consideration of the measure from the Education and the Workforce Committee. We're happy to welcome both the chair and the ranking member of the full committee. And Mr. Andrews is scheduled to be here, too, as a ranking member of the subcommittee, and so we will include him. That's why we have the empty chair here. We're looking forward to his arrival before too terribly long. And I will no, he's not here, George, I'll tell you. So, I mean, I would have spotted him. So let's begin. And gentlemen, as I look to both of you, you have what appears to be beautifully prepared statements. And I'd like to say that without objection, all of your statements will appear in the record in their entirety, and we would welcome your summary. So, Chairman Klein.
Thank you, Chairman Dreyer, Ranking Member Slaughter, members of the House Rules Committee. Appreciate the opportunity to testify today in support of H.R. 2587, the Protecting Jobs from Government Interference Act. I'd also like to take a moment to thank Mr. Tim Scott, the sponsor of the legislation, not only for his leadership on behalf of workers, but for his leadership in this Congress. Last week, the House Education and Workforce Committee approved the Protecting Jobs from Government Interference Act. This legislation simply says the National Labor Relations Board should not be empowered to tell a business where it can and cannot locate employment. Mr. Chairman, taking advantage of your offer to have this included in its entirety, let me summarize the situation. The National Labor Relations Act controls relations between employers and employees. The board is supposedly constituted of 5 members. It has, decade after decade, shifted back and forth with the majority Republican and Democrat members, and each side complains about the board year after year as that majority shifts back and forth. In this case, the board, the acting general counsel, this case being the decision concerning Boeing, the acting general counsel ruled, and I understand this is an ongoing process, that Boeing could not establish a plant in South Carolina, a plant they'd already spent $1 billion building, already hired over 1,000 employees. That ruling has sent a chilling effect across the country as employers and potential employers make decisions on where they want to put their plant or where they might want to expand a plant. We believe that is a job-killing decision. It has already affected, I am quite certain, employment, not only in South Carolina, but around the country. It's going to make employers think about whether they want to build in this country or another country where they're out of the reach of such a board. We believe that we need to remove this one remedy that the board has. It's a draconian remedy. It is the economic death penalty, I think one of our colleagues said the other day. So our board simply, our bill simply says, National Labor Relations Board, you cannot use this extraordinary draconian remedy and tell companies where they can and cannot operate. With that, I'll yield back.
Thank you very much, Mr. Klein. Mr. Miller.
Thank you, Mr. Chairman and Ranking Member Slaughter for the time, and I will submit my statement. This bill is very fundamental. It's very important. This bill does two things that are deeply troubling. They would certainly be troubling for working people in this country who want to exercise their rights at work. First and foremost, this legislation is designed to assist a special interest. That special interest in this case is the Boeing Company, a Fortune 500 company that has been charged with the allegation is that they unlawfully transferred work from Washington to South Carolina in retaliation against workers in Washington exercising their rights under the law. In this case was a strike. The law doesn't let you do that. That's an illegal act under the law. Whether or not Boeing is guilty of that or not will be determined by the ALA law judge, and there will be appeals if people think they want to appeal if whatever the decision is made. But this legislation comes in the middle of that process and says we're going to take this remedy away. Now you have a pretty public discussion of Boeing executives talking about why they weren't going to have this work in Washington. It was related to the strikes. They were tired of the strikes. But under the National Labor Relations Act, you don't get to retaliate. That is against the law. an employer, a company owner, or shareholders, whatever the makeup of a company is, they can locate anywhere they want. They just don't get to do it in retaliation against the lawful exercise of rights at work by the workers. And what this legislation would do, if you take away this remedy, it takes away the only effective remedy on an employer simply deciding when somebody comes to you under the law and says, I'd like to have a union, you can fire that person. You can take away their work. If they come to you and say, we're going to have a strike, you can say, well, I'm going to move my plant. We're going to do this work elsewhere. All that in violation of law. Today, those people have a remedy. What that remedy will be in the Boeing case, nobody knows. There were months and months, or almost a year of discussions before the filing, and there's been discussions suggested by the judiciary officer that happened. But the question really here is whether or not working people in this country for all different types of businesses, whether or not they will have any rights at work. The idea is they say, well, there are other remedies here. You can get back pay. You can get back pay in many of these cases. So very often these cases that right is challenged. So a person who's illegally perhaps lost their job, even if it's ruled that in fact that's right, they did illegally lose their job, they can be hung out to dry if they can get an attorney, if somebody will take their case for months and months or years and years. Back pay when you're a working person in this family that's seen their median income drop over the last decade, you can lose your house, you can lose your car, you can lose your kids' education before you ever get to the bar of justice to determine whether or not you're entitled to recovery. So this bill just fundamentally strips workers of the protections that they have at work to do what they've been doing since 1937, and that is deciding whether or not at any given time they would like to organize that workplace. Would they like to all sign a letter for a safer workplace? Would they like a different mix of benefits? All of these actions now, under the law, employers are not entitled to retaliate against you by taking away your work. And the end result is that one of the major challenges that's made to the efforts to organize a workplace is that we'll move the job somewhere else. We'll go overseas. We'll go down south. We'll go up north. Whatever it is, you can do all that. You just can't do it as a matter of retaliation. So now, when people are trying to organize a workplace, or they're trying to get a safer workplace, or they're trying to change their hours, whatever it is that rights they're trying to exercise, the employer can say that, and the employer can do it. So now, where do people get the courage to speak up? Where do they get the ability to talk about these issues at work? And the one thing that they can do now is that they can decide that the strike was detrimental. They just outsource the work. They can decide they can outsource part of the plant. These people wanted to organize over here in the paint shed, or they wanted to organize over here in the machine shop. Well, we're going to move that work overseas. And so it really is a license to race to the bottom here in the United States, and it's also a license to outsource work while retaliating against workers who did nothing more than exercise their rights under the law. It's a very draconian measure, and it really is a decision to put our thumb on this scale of justice in the middle of a trial on behalf of the corporate entity here against the workers and against a fair hearing on these issues. This comes at the end of many actions taken by this committee and the Committee on Government, what do they call that committee? Oversight. To try and subpoena evidence and the deliberative documents of the judicial officers and the National Labor Relations Board in this action. It's really wrong.
Well, you sound less than enthusiastic about the bill itself.
No, don't make light of my remarks. This is a
fundamental
fundamental wrong being done to people.
Mr. Andrews.
Thank you, Mr. Chairman. I apologize for my tardiness. I'll be very brief. I share Mr. Miller's strong opposition to this bill for two reasons. First is a lot of people live in towns that are littered by bordered and shuttered businesses and factories. And not only do these bordered factories mar their communities, they mar their lives. These are people who their entire lives played by the rules, went to work faithfully, did what was expected of them, sacrificed for their company, thought that they would have a job until the day they retired because they earned it. They earned it working so hard. and they found out that one day that the plant moved to Malaysia or the call center moved to Indonesia. I think that this bill is really the outsourcer's Bill of Rights, the way it's written. Because what it says is that even in a situation where a company is undergoing an organizing drive, where some of those employees have said, you know what, we want to have a union here, we're going to start to collect cards, we're going to try to have an election, we want a union. If the employer were to say, well, because you're organizing this union, I'm shutting the plant down and moving it to Indonesia. Under present law, that's retaliation, and there are remedies that the National Labor Relations Board can take to stop that. Under the bill that's before us, although it would still be illegal to do what I just said, there would be no effective remedy to stop what I just said. So this really paints a roadmap for an outsourcer as to how to do it, and Lord knows I think we've had enough outsourcing. The second objection that I have here is that this bill is really designed to interfere with an existing case. The Acting General Counsel of the NLRB has filed a complaint against Boeing alleging that Boeing has discriminated against its workers in Washington State because they were exercising their collective bargaining rights and moved work to South Carolina. It's an allegation. That allegation is presently the subject of a trial in the administrative law courts, and the judge will either decide that Boeing committed this offense or didn't commit this offense. What this bill does is to say that if the judge, based on the evidence in front of him, decides that Boeing has committed this offense, one of the remedies that the board and the court may not order is the restoration of this work to the workers in Washington. The whole principle here of interfering with an ongoing case, I think, is troubling. And so for those two reasons, I would respectfully urge, I'm going to oppose the bill. I would say this. Mr. Miller and I are recommending to our colleagues that we not file amendments because we think the bill is so fundamentally flawed that improving it is really beyond the realm of possibility. Thank you very much.
Thank you very much for that, Mr. Andrews. Let me say we have the benefit of the author of the legislation, Mr. Scott, here, and if you'd like to say anything before we go into questions, Mr. Scott, you certainly are welcome to. As Chairman Klein mentioned, you're authoring.
Thank you very much. Chairman Klein, I thank you for taking up this bill and moving it forward, and I look forward to seeing the debate on the House floor tomorrow during the rules as well as the overall debate. But I keep hearing these words used that I really need help defining. As a common man without a law degree, perhaps you guys could help me with the definition of the word restoration and transfer. Sincerely.
Well, Mr. Scott, if you would, one of the remedies that's available to the Labor Board, if a violation is proven in court, would be to enjoin, that is to stop the transfer of work from one place to another. And whether the facts of this case support that or not is in dispute. A, Boeing would say they didn't do anything wrong, and B, they would say they already moved the work, so it can't be restored. But my point would be there is a legal process to answer those questions, and it doesn't belong here.
Well, I just wanted to know the definition of the word transfer, not the overall conversation or the case itself.
Well, in this case,
the
would yield. In this case, the word transfer would mean that the work in building and assembling these airplanes that had previously been done in Washington would be done in South Carolina.
Good, thank you. So, Mr. Chairman, part of the conversation that we should be having is about definitions of words, because obviously the definitions that we typically use in the common world don't apply to the NLRB, because fact be told, the definition that he just uncovered is consistent with the definition that I use for the word transfer. Unfortunately, when you look at Puget Sound, Washington State, there simply have been no loss of jobs. So you can't transfer back that which has never been lost. Number two, restoration would give the same consideration to the definition of the word transfer. So the fact of the matter is that when you look at Puget Sound, Washington State, the fact that there have been no loss of jobs by the union folks, and they've actually added jobs, albeit probably temporary jobs, they simply have more people working in Puget Sound than they have today. And the assets, the transfer of assets that we discussed earlier, was that Mr. Miller talked about the transfer of assets. The notion of transferring work that never existed in the primary location, it's very difficult to transfer them back. Restoring jobs that were never lost, it's very difficult to restore back jobs that were never lost. And so the fact of the matter is that the 7 planes that were being made in Puget Sound, Washington State are still being made at 7 planes a month. The new line that Boeing decided to add, the new line, which is very important in this entire case, and the new line that is being worked in South Carolina is an additional 3 planes being made at a new location with new employees. So the real question is if, in fact, the whole case, and according to Mr. Solomon, who came to Charleston very kindly, and stated that his case was about the transfer of assets. When I asked him to define the word transfer, he came up with a very similar definition, which is that those assets that existed one place need to go back to where they came from. So I asked him what assets were transferred. He simply said that hypothetically the assets could have come to Washington State. Well, hypothetically, Boeing could become a Chinese company or Brazilian company and not exist under the NLRB regulations whatsoever. So the effect of this really has a long impact outside of definitions of words.
If you yield.
I'm happy to yield.
You could also make a determination that and again, I don't know what the NLRB will do, but you could also make a determination that the 2,100 jobs that are temporary in Seattle could have been permanent, because those jobs are created because the South Carolina facility is not prepared to meet that demand. You would also could argue that, in fact, when you're talking about assets, you're talking about, it was pretty clear from the reading in the public press of the CEO's remarks, that future work wasn't going to go to Washington. So they're transferring.
Reclaiming my time, I would say that the fact is that when you look at the 2,100 temporary jobs in Washington State, there's no question that if you were to add a new line of business, perhaps in a new line of business, they would hire more employees. I would say that's actually right. So the question is, can a company use as a part of their determination of where they want to locate their competitive position in the world? And the answer is, of course, that they can. And so if in fact they decided that the best place for them to do business and make a profit is in South Carolina, the question then remains, if they're going to take jobs from one location and transfer them to a second location, then they're transferring jobs. But if they're not actually transferring jobs, but creating new jobs and keeping the exact same jobs that they currently had at the primary location, have they transferred any jobs?
If you read the CEO's remarks, it would suggest to you that but for these strikes, these jobs would have been dealt at the facility in Seattle for that portion of the work. And now they're not going to be. So if you have a career as a machinist.
While reclaiming my time, I would simply say that if you take into consideration, I can't say that the Boeing company did, the effects of a 53-day strike costing them $1.8 billion, can you take the competitive position and the issue of profit into consideration when you're going to do your new line of work? I'd say I'd take all factors into consideration when making my decision, and then find myself at the cusp of the decision and make a decision that's based in the best interest of my stockholders, my employees, and the company itself, and then find yourself wherever you find yourself. Please land there. So the question of profitability.
That will be a determination.
But you asked that we're talking about the actual facts and not the hypotheticals.
No, but deal with the actual facts. What you're doing is
facts are. I'm sorry. I've reclaimed my time, so I'm not going to let you. I'm not going to allow you to sit over here and over-talk me. You can talk as long as you want to, but I will continue. So I would simply say that the facts of the case are very clear. The hypotheticals of the case are not clear. The facts of the case are very clear. And the facts of the case are, if you want to transfer assets that were never transferred, you can't transfer them because they were never there. So I would say that the entire case itself is preposterous. However, this is the federal government, so we can do all kinds of neat things with taxpayer dollars.
We'll continue.
Certainly.
I thank him very much. I actually think that this exchange is compelling evidence for why this is the wrong place to have this discussion. There's a judge sitting today who is hearing all the facts, all the testimony, reading all the documents, and he's going to make a decision and apply the law. This is the equivalent of having a complex antitrust case in traffic court, because the place hearing the case isn't prepared to do it. We should let the judge do his job.
Final question, Mr. Andrews. Yeah. How many times has the NLRB used the relocation?
Well, how many times have they used the remedy of enjoining the transfer of work?
How many times have they transferred?
It's voluminous times. I could give you a specific number. We can supplement the record. One case I can tell you about in 2000 in California, there was a jewelry company that was being organized by some workers who wanted to join a union. The owner of the company announced he was going to move the jewelry work to Mexico. And there was litigation in that case. The United States District Court eventually heard it and said he couldn't do that. They entered an injunction, stopped him from doing it. There are numerous cases like that.
And he was going to, what was the facts of the case? He's going to transfer the jobs to Mexico?
Mhm. And he did so, the evidence on the record, as determined by the court, said that his motivating factor was to punish the people for forming a union. And that was found to be a violation of the Labor Act, and there was a remedy.
And the great challenge of this case is simply that Boeing continues to work effectively with their union employees in Washington State with no loss of jobs. And at the same time, they've decided to do additional lines of work, new lines of work with new employees in South Carolina. We are talking about one of the greatest job-killing opportunities our nation faces today.
If the gentleman
with,
I don't
yield actually.
Okay.
With our greatest exporter in the nation. Thank you, Mr. Chairman.
Well, that was interesting testimony, Mr. Scott. You chose the time for testimony to engage in discussion, so rather than yielding to recognizing Mr. Sessions, I'm going to recognize Ms. Slaughter.
Mr. Chairman, Ms. Slaughter, would you yield just a moment with your, Mr. Chairman, with your permission?
No, Ms. Slaughter is recognized, and she's chosen to yield.
Well, just for a moment of personal privilege, we have visiting with us today Jik Nouri, Damien Jik Nouri, who is a member of the Assembly of Albania, and his colleague. And I just wanted to make sure that our colleagues knew that in that assembly are an extraordinary number of people who are supportive of American interests as it pertains to terrorism, Afghanistan, and other significant mutual relations that exist between our countries. And he's here having had good meetings, and I wanted you to see.
Well, gentlemen, thank you very much. We very much appreciate your being here, and hope you won't take what you've seen. You've witnessed rigorous debate, and I hope you won't take everything that we do back to Albania with you. Ms. Slaughter.
Thank you, Mr. Chairman. Since Mr. Miller nor Mr. Andrews were really allowed to ask questions of author, I want to give you a chance to do that. What comment did you want to make, Mr. Miller?
Well, the comment just was the question of, the question of whether jobs have been moved or work will not be given to this facility in retaliation for the strike that they had at Boeing is a question that, as Mr. Andrews has pointed out, the NLRB should be allowed to make that decision. We're in the middle of the process of putting our thumbs on the various sides of the scales of justice here, when in fact we don't have all of the facts in front of us. We're not sitting here as an impartial to take a look at this. And that's the point I was going to make. That,
Mr. Andrews?
The company, the workers in Washington have been told that this is the future of the company. This is the future of aviation. The 787 is there. The jobs here are temporary. You're building that product. You obviously have the wherewithal, the talent, the skills, and the history to do that. But that's all going to be phased out because now the jobs are going to go to South Carolina. I mean, again, they're just playing off one set of workers against another.
And, Madam Chair, let me also say what's wrong with this interference if you put the litigation shoe on the other foot. There was a major case involving gender discrimination alleged at Walmart. There was a class action filed, and the allegation was that Walmart had systematically discriminated against women for hiring and promotion. And very recently, the United States Supreme Court decided that the class that was certified in that case was invalidly certified, therefore sort of winding the litigation down. Now, I don't know enough about that case to know whether I agree or disagree with the decision, but I do know this. If we had passed a statute that said we're going to change the class certification rules with the case already underway to make it easier for these women to sustain a class action against Walmart, I think that our friends on the other side would have protested long and loud about interfering in a piece of pending litigation, and they would have been right, because there's a set of rules that you litigate under, you either win or you lose. And I think that's exactly what we're doing here, and it's an unwelcome and I think even dangerous precedent.
Right. I'd like to put the administration statement in. The administration opposes H.R. 2587. It undermines enforcement of the National Labor Relations Act. The NLRA establishes the legal rights of employers and employees with respect to workplace organizing and collective bargaining. The NLRA does not restrict the location of company operations, provided companies comply with the law. H.R. 2587 would leave employees no meaningful recourse in certain situations where an employer has violated the NLRA. I would like to ask unanimous
I
consent
guess you don't
put
need to
this
ask
in the
unanimous
record.
consent to enter in the record. You've just entered it in the
Yeah, I
record.
just
by
did.
virtue of having
I want
read
it
every word
twice.
of it.
Okay, thank you. Gentlemen, obviously, we've seen terrible assaults against American workers in the last 6 or 8 months, almost blaming them for what happened to financial services and doing what we can to hurt them. At the same time, from a House of Representatives is creating not a single job, maybe 4 the other day, we agreed on the floor. But I agree with both Mr. Miller and Mr. Andrews that the most critical thing here is that we are really violating separation of powers, I think. How do we interfere in an ongoing trial in the judiciary system? We've never done that before. Is this a first?
Well, we did it in the Terry Schiavo case.
The Terry Schiavo? Oh, yes, yes. But, oh, boy. I don't know. Some days I think we won't recognize this place in a year or two. Could we talk about process? This was introduced and pushed out of the committee in less than 48 hours, correct?
Yeah.
Was there any hearing on this bill?
We had previous hearings, not on the legislation, but on the issue, on
On the concept?
NLRB, right?
Yes, we had 3 hearings referencing NLRB, 2 of them post Leif Solomon's Boeing decision.
No objective assessments by the GAO, Congressional Research Service. No evaluation of the impact on wages and job security of millions of workers. We're going to be touched by this legislation. Is that correct?
Yes.
At the markup, as you said before, Mr. Andrews, the Democrats protested and we have no amendments. And I think we should follow that through because this really is, to me, one of the saddest things that we've seen for many grounds. But this absolute frontal assault on the workers in America and to help create more outsourcing makes literally no sense to me. Just as yesterday made no sense to me when we are going to be mining at the Grand Canyon to give uranium to Russia. I've tried to think about that a lot. It's sort of like Alice in Wonderland. Can you believe 8 impossible things before breakfast? I find most of the times I can't. Thank you very much.
Thank you very much.
Mr. Chairman, I noted, it looks like he's walked out, but a friend of mine from California, Brad Smith, was here, and I wanted to acknowledge him, and I'm sorry that he is not here at this time. Mr. Chairman, there's been a lot of discussion about cases and ideas about outsourcing and foreign components. A number of foreign countries have been mentioned. Is there anything in this that would be a transfer of a job to a foreign country?
Does not change the law. It merely removes a remedy, and I would argue the most draconian remedy. In fact, I would argue that absent removing that remedy, we're going to be impairing job creation in this country. Companies across the country are looking at this decision and making decisions. Do they want to expose themselves to a decision of one man and then administrative law judge and then a board which isn't always a partisan board, or do they want to place their work someplace else? So if we're really trying to get Americans back to work and get companies to have the confidence to open plants and put Americans back to work, we need to pass this.
Mr. Andrews, the word outsourcing was just addressed. Do you believe this is an outsourcing issue?
I do, yes, Mr. Sessions.
Because it's one company within the United States? That's outsourcing?
I think it paints a roadmap, Mr. Sessions, for outsourcing in the following way. It says that if you have workers at your place of business that are organizing, and you choose to deal with that organizing drive by moving your place of business somewhere else, either in or out of the United States, you're now protected against that as an effective measure. There are remedies, but let me give you an example of what one of the remedies is. There's a back pay remedy. So if the board would find that you had, as an employer, had retaliated against these workers who are trying to organize, you could get them back pay. Here's what you do. You would set up a subsidiary entity to run your business in another state or another country. You would leave a shell entity back to where you were working, would have no assets, and the workers would have a meaningless back pay order against an employer with 0 assets. That's what you do. And so if you take away the effective remedy, which is enjoining the movement of the work, which is retaliatory, then yes, I think this is a map for outsourcers.
Shell entity, is there a shell entity being created or even contemplated for the movement of these actual employees that we're speaking about with Boeing?
In the actual case of Boeing, certainly not.
Then, Mr. Andrews, why would you bring up the issue of shell entity?
Well,
If
because
that does not apply to the issue that's before us, or does it?
it doesn't apply to the singular case that the majority is trying to adjudicate through the legislative branch.
Let's go
But
to
does-
the real
but it does-
issue.
But it
You've
does
looked at
apply
it more
to
than
others
I.
that would happen.
Well,
By the way, the
let's-
reason Boeing won't be a shell entity is a defense contractor.
So they're not a shell entity.
At most especially not. I hope they never are. But
So
they're a
in
defense
other words, your
contractor. It
argument
has
that
still
you're trying
stay
to
in
apply
business.
this to does
But
not.
somebody that's a call center or a retail store or a software company could very easily create a shell entity. Very easily.
Are you aware of, in the past, circumstances, and the only reason I say is I'm aware of at least one, living in Dallas, Texas. We had have a GM plant, what's called Arlington.
Mm-hmm.
And within the GM system some years ago, let's say 8 or 10 years ago, there was a competition between cities, between plants, about how and who would handle and get this new line of business. I believe it's called a Tahoe. It was about a Tahoe. And there was a competitive issue that took place where literally the work groups as a team took this on, and there was a determination about where they would move the work based upon flexibility, based upon a number of factors up to and including a desire to the workplace to adapt itself to the needs of the accommodation of the building of the vehicle. What do you think about that?
I think it's perfectly legal under the laws that exist today. I assume under the facts that you've outlined, Mr. Sessions, that there was no discrimination against or retaliation against people trying to organize a union. And if that's the case, then General Motors was entirely within its rights to do that.
So they were pitting, in essence, an offer against all, at least I think 3 of the different components or areas that could
Yeah.
have been doing it. So you think that's a fair thing within the company to, in essence, offer a bidding process?
Yeah, on the surface, I do, and more relevant to this discussion, it's a perfectly legal thing. It does not violate the National Labor Relations Act, nor would it when this bill fails.
Mr. Klein, do you believe that in the participation by management where they're trying to determine the growth, the needs of the business, that the management of a business would be allowed to do exactly what we talked about with the competing within the elements of these 3 groups? Do you believe that management should be able to determine whether they're going to grow, where they should go, what might be best for that, and to lay out a plan and to grow their business and be able to do these things? Or is there
Ms. Sessions, of
something
course, no.
in the law that should prohibit us from doing that from a management perspective?
No, that's, in my judgment, that's exactly what management is supposed to do. They're supposed to decide where they can go and be the most effective, the most productive, keep their company growing, keep hiring more people. Those are management decisions, and they're supposed to make them.
As the chairman of the committee, do you have a concern about what the outcome of this court case might be?
Well, I have a concern already about what is going on, and there's no doubt in my mind that there are businesses right now, some of them in South Carolina, perhaps they were planning to put in a new store, a new sandwich shop, do something in support of the thousands of employees that Boeing was in the process, had already hired over 1,000 in the process of doing. So even though this is a decision by one acting general counsel, and as Mr. Andrews correctly said, it's going to go through a process, it would be very inaccurate to say that nothing has happened. Decisions are already being made, business decisions, based on the decision of one acting general counsel.
Do you believe, Mr. Klein, as chairman of the committee and a person who has looked at this, that this could mean that if there is some sort of decision that might be adversarial to this process, that people would simply move their jobs overseas as opposed to in America?
They may move their entire company overseas. They may choose to start up overseas. They probably would choose, some companies would choose to establish their business outside the reach of what is always a partisan political group, the National Labor Relations Board, put themselves outside of the reach of that because clearly you can have a draconian outcome, a horrific, and if you live in South Carolina near Charleston, and I drove by that plant, beautiful plant, by the way, Mr. Scott, brand new plant, this decision forces them to close that down, fire all of those workers there, and all of the people who were planning to create jobs in that area are now out of business. Well, this is truly an economic death penalty.
Mr. Klein, I don't expect that you might have looked at the contract of all the things that Boeing may be contracted from to use in this plant, but do you believe that Boeing has an obligation to prepare themselves at the best cost, the best product, as an obligation to their customers, and thus to select where they do the work and keep costs low and pick people who can best do that work?
Well, of course, I believe they do. They have an obligation to their customers. They have an obligation to their owners, to the stockholders. They have a fiduciary responsibility. And clearly, not only is it a question of decisions being made potentially by businesses in and around the area of Charleston, South Carolina, but major companies looking at Boeing are making decisions on whether or not to buy their airplanes if they're worried about a work stoppage, for example, and there's been much discussion about that. They may split their buy with another company, perhaps an overseas company, rather than do all of their business with Boeing because they have business concerns. And my position is that for the National Labor Relations Board, very small group, always politically appointed, and acting general counsel to come in and have this level of impact is completely over the top and is a job-killing decision.
Mr. Klein, I too have seen, not from a perspective of walking in, but rather landing at the airport, I've seen the Boeing facilities that are rather dramatic and leading edge in their nature, and I too agree with you. It would be a big boom for not only that region, but also for the company to stay leading edge. Mr. Chairman, and I thank you. Mr. Chairman, I'd like to ask unanimous consent to put in the record today an article that was in USA Today, Texas bucks national unemployment trend. And by and large it says move to Texas. I go all over the country and visit, and I cannot say that anybody should move to Texas, but what I can say is that we as a country, the United States, will continue to lose jobs as long as government becomes engaged in the free enterprise system to the detriment of employment and employers. And I'd like to ask unanimous consent
Without
that that is
objection,
included in
the
the
article
record.
during the record.
I yield back my time.
Mr. McGovern.
Thank you, and I thank you all for being here. And I agree that this is a bill that is pretty cut and dry. That we shouldn't be offering amendments to it because it really can't be made any better. I guess as I listen to my colleague Mr. Scott, I mean, if the case is a slam dunk, like he says, let the process work its way. And my guess is that, I think that the people in the National Labor Relations Board, by and large, are pretty reasonable people, and let's see how it works out. But we're midway through a case. But what bothers me about listening to this discussion is that it seems like there's in this Congress that there's always this presumption that workers are bad, that workers are always wrong, that workers shouldn't complain, that workers shouldn't demand their rights. And that really is a formula for a race to the bottom. I mean, there are some great companies, wonderful companies in this country, great profitable companies. Boeing is a great company. But sometimes great companies behave badly. And when they do, there ought to be some remedy for the workers. I mean, the workers are the people who actually work in these factories and work in these companies, and build these companies up. And this notion that we should have a race to the bottom, that's about lowering the standard of living for people in this country, lessening the quality of life. We should be trying to find ways to lift people up. There's nothing wrong with workers demanding to work in a safe workplace, or if they're being treated badly, to be able to demand their rights. And let me just say one thing about union organizing. It's tough to organize a union in the United States of America. It's not easy. And for those of us who have seen organizing efforts in our own district, you know it takes a lot for workers to want to come forward and risk the potential retaliation. I mean, you know, because the job is all they have. And usually when unions spring up in places, it's because the workplace is not going well. It's bad. Because it takes a lot of guts to organize a union. And let me ask you a question. Is this bill retroactive?
The bill pertains to any case where final adjudication has not been made. So, yes.
So what happens in the case, Mr. Andrews, that you mentioned, the California case, if this were to become the law? What would happen?
Well, that case is over, but I will say that any other case where a final order has not been entered or the appeals process has not been yet exhausted, this remedy would be revoked. So any other pending case where one of the remedies being sought is an injunction against shifting work, the remedy would no longer be available.
So no matter how, you know,
Doesn't
cut
matter.
and dry the case may be in favor of the workers, it would go.
The merits are irrelevant. If it's the best case in the world from the point of view of the complainant or the worst, the remedy is no longer there. It's extinguished.
Now, under this bill, if a company closes an entire U.S. plant or part of a U.S. plant and move the work to China because U.S. employees organized a union, the NLRB would no longer have the power to order the work be kept in or returned to the United States. Is that correct?
That is correct.
And so that goes to this issue of outsourcing that Mr. Sessions brought up. I mean, that is a real concern. And this bill does nothing about creating jobs. I mean, what we're talking about here is, in this case, jobs that should or may not have stayed in Washington have gone to South Carolina.
You know, Mr. Governor, if I may, I think it reflects a philosophy that's the precise opposite of one of the great American capitalists, Henry Ford, who had the very radical idea for his time that he would pay his workers more than the market would bear because he wanted them to make enough money to buy the cars they were making. And that kind of enlightened long-term entrepreneurial spirit helped to build the middle class of this country. This is the opposite. This really says race to the bottom, pay as little as you can. And what I worry about is when you do that, there are very few people left to buy the product that you're making or the service that you're selling. And what you wind up with is a diminishing middle class, a growing number of poor people, and a few people at the upper end. That's not really the America that I think we want.
Mr. Miller. Well, I would join in that, and I would also say that in the current situation, again, not knowing how this is going to be decided, but in the public expressions by the CEO about moving the work to South Carolina because of the strikes that take place in Puget Sound, as he said, you're also sending a very strong message to the new employees at South Carolina. Don't even think about a union. Don't even think about organizing. Don't even think about grievances in here. Now, remind you, this is a product of which I think some 70% of it was outsourced. You know, it's a sort of a new form of manufacturing that Boeing experimented with and getting good reviews and bad reviews by different business journals. But the fact of the matter, some 70% was outsourced and nobody was arguing about it. But in this particular case, you're sending a very strong signal to where that work is going. I would suggest even as they struggle in China with work stoppages, you're sending a signal there that don't even think about this. Because we showed you with one of the stronger, longer labor relationships in our country, that of labor and Boeing in Puget Sound, that we can take these kinds of actions. So this message flows both ways. It flows both ways. It's a message to the people who remain in Everett, in Everett and other parts of Puget Sound, and it sends a message to where the work is going. Yeah, and let me just close by saying I think what bothers me about, it's just not only this bill, it's about so many other things that we're doing in this Congress, is that, you know, we're forcing Americans to fight each other over existing jobs by giving up their rights and underbidding each other. And it goes to point you raised, Mr. Andrews, referring to Henry Ford about paying his workers enough so they could be able to buy a car. I mean, we really are engaged in a race to the bottom here in the United States amongst each other. I mean, and that's not even putting in counting the issue of outsourcing. And it really troubles me because, again, we should be about lifting people up and trying to find ways to, again, help people be able to afford automobiles and afford homes and be able to afford to send their kids to college. And this bill seems to be moving in the opposite direction. I understand where Mr. Scott is coming from. It's your state, your district. I get that kind of parochial issue, but there's this larger pattern going on in this Congress about lessening the quality of life for people, and I think that's a bad way to go. I yield back my time.
Thank you very much, Mr. McGovern. Before I recognize Ms. Fox, I'd like to say that we're very pleased to be joined by Mr. Nugent's wife, Wendy, who's here with a couple of guests. I don't know, Mr. Nugent, if you'd like to introduce.
That's my sister-in-law, Lauren Fritz.
Great. Wonderful to see you. Thanks very much for joining us. Ms. Fox.
Thank you, Mr. Chairman. I want to thank Chairman Klein for his leadership on this bill and for our colleague, Mr. Scott, for the work that he has done. I would say that I really take offense at comments being made that those of us on our side of the aisle think workers are bad, always wrong. I have entirely the other attitude about the American people. I have great faith in the American people. It's average people who built this country, who built this economy, and I think it's those of us who want to see less government interference in our lives who really have faith in the American people, who believe in them and want to see them be able to use their talents, use their skills, and their God-given abilities to continue to make the government, the country, a great country. And I think getting the government off their backs and allowing them to use their talents is the best way to do it. And I think there is a great difference in philosophy in Washington. We're being told all the time we need to compromise and get along. But it is a hugely different philosophy toward the American people, and we have a strong belief in the American people and their ability to take care of themselves. We don't think the government or the unions need to step in to look after them. And I would say I would support this rule and support my colleagues who are putting the time and energy into pushing the legislation. So thank you very much.
Mr. Hastings.
Thank you very much, Mr. Chairman, and I thank you and Ms. Slaughter earlier for letting me introduce my friend who was visiting here from Albania. Dr. Fox, union people are Americans too, and occasionally it seems that we forget in this country the extraordinary development that is pure capitalism, pure entrepreneurial, and has been supported, as Mr. Andrews and Mr. Miller have pointed out, supportive of the development of the extraordinary middle class and upper class in our overall society. Many of you are old enough to remember many of the companies that had nothing but union workers, some that still exist, and some that are gone. I take a personal point with reference to my father, who was a person that never went to school a day in his life and lived and was born in the halcyon days of segregation in this country, as was I. On a given night in 1943, during the Second World War, in Florida, he said to my mother, that we need to move. And we moved to Jersey City, New Jersey. My mother went to work in a button factory in Brooklyn that was unionized. My father went to work at Hackensack Roller Barron in Hackensack, New Jersey, that was unionized. All of the people, he brought his brother up from Georgia that became a longshoreman in Jersey City and died a longshoreman that was unionized. Many of the companies, Ms. Slaughter's main company, during the course of her living in that area of New York, Kodak, is a place where many workers from the high schools and elementary schools in Florida that I attended wound up that were unionized. Mr. Andrew, that were in areas that were union available. Mr. Andrews mentioned Ford Motor Company, who also had plants in New York and other places that were unionized. There are countless structures in this country today that were formulated and developed in conjunction with employers and employees that were unionized. And we just got through seeing completed yesterday a dispute between billionaires and millionaires about football that is unionized. Unions are Americans too. And somewhere along the line, I genuinely, my good friend Mr. Scott, I have no quarrel with any of our locales and or parochial interests having companies to move to our areas. But pitting workers against each other within the same structure is not my way of understanding what it is that has helped the development of this country. Pressing people downward is not my way of what I think is in the best interest of this country's workers or their employers. Mr. Klein, Mr. Chairman, in a letter to the committee, the AFL-CIO, Government Affairs Director Bill Samuel, wrote to you and the other members of the committee that this bill, in his opinion, would cripple workers, hobble the National Labor Relations Board, make it easier for companies to ship jobs overseas, and create a new race to the bottom for American workers. What, if any, reaction would you say, or did you say, in response to that statement?
Well, I disagree completely with that statement. Not surprising. I think I've made that fairly clear here already today. I believe the opposite is true. I think that this decision underway right now is in fact crippling jobs and hurting job creation in this country, and that the action that we're taking in this bill will help create more jobs in this country rather than have them created overseas. And I do want to identify myself with your remarks that union workers are indeed Americans too. I drive a wonderful Ford Ranger built by union workers right in St. Paul, Minnesota. That's not the issue here. What we're talking about, I believe, is an overreach by a board that administration after administration, Republican, Democrat, gets very partisan. And when I remember very well when my good friend Mr. Miller was the chairman, he was mad at the NLRB under the Bush administration, and I complained, and now vice versa. It can be. And in this case, we have a decision by one acting general counsel that's starting a process which I am arguing is already having a devastating effect on job creation in this country.
And there is a lawsuit in progress with reference to it. Am I correct?
It's an ongoing process, administrative law judge, then the board, then it'll be appealed, and all while all this going on, there's great uncertainty.
Understanding that, and with us interceding the way that we are, Are we establishing a precedent, not just in this particular case, but are we establishing a precedent of undermining one of the more fundamental aspects of our government, and that is the court system?
I don't believe that's the case. We're
Well, why
taking
don't
away
we-
one draconian remedy. The act remains in place. They're either violated the law or not, but we're taking away a remedy which we're arguing is highly detrimental to creating jobs in this country.
Well, what then, Mr. Miller or Mr. Andrews, are the rights of the workers when all is said and done? If this passes, what would be a remedy for an American worker if and when their rights are violated?
Well, if this was not the law, I would say under this particular case, this right wouldn't exist. I guess the theory would be if they could prove the case, which means that they were retaliated against for their legal union activities or legal rights at work, if you will, there's a possibility of back pay. But again, the history is that that's a very long, drawn-out process for many workers. Either they can't afford to go through it or the back pay never.
Simply put, it's taking away workers' rights.
Yes.
And
No, there's no question about it.
added to that, I don't understand then how taking away workers' rights creates jobs and strengthens the economy. I just, for the life of me, don't understand that. I also understand union busted when I see it, and I don't like it. I thank you, and I yield back.
Mr. Bishop.
Maybe I'm confused right now, since I'm an old AFL-CIO member. Does that mean I'm better or worse?
No, it just means
You're equal.
that you are an American.
Okay, I'll take that. Mr. Andrews, Rob, you said there were voluminous examples of this kind of movement, and you gave one from a state to a foreign nationality. Do you have an example of one that's gone state to state?
Not off the top of my head, but I can supplement the record.
But there are some.
There are some. There aren't many. And I'll tell you what typically happens
But this
here.
means this is a systemic issue. It's not just
It
an
is.
isolated issue.
One point of reference,
Okay.
Mr. Bishop, that I believe it is, I may be wrong about this, but it's
Just be careful. I don't want to know too much information. I may get confused.
a huge, 80-85% of these cases are settled before there's a remedy imposed or some kind of settlement. So decided cases with remedies are fairly rare,
Right.
but there are examples of this kind of remedy, yes.
But, okay, but I appreciate you telling me this is not just isolated.
This is, no.
Thank you very much. I yield back.
Thank you, Mr. Chairman. I come from a right-to-work state, so a lot of this is foreign to me. You talk about, Mr. Miller, why it is that one would get involved in the middle of an administrative proceeding, and you correct me if I'm wrong. I did not know this, Mr. Andrews, but I'm told you're were once one of the leading labor lawyers in this land before you gave it all up to serve the people here in
No, I wish that were true. That's not true.
I had no idea.
I was a real estate lawyer, Mr. Woodall, back when people actually bought and sold property.
I'm going to
back
have
in the
to
old
change,
days.
get
No,
my
I was
information from
never a
better
labor lawyer, Mr. Woodall.
But coming out of the great state of Georgia, I had no idea that if you were doing business somewhere and it turned out that this was not a favorable climate in which to do business, and you wanted to pick up your business and move it to a neighboring community or a neighboring state, there were federal laws on the books
You can do
that
that.
said no. Apparently not if being in a labor union
You can't-
is one of those negative.
The National Labor Relations Act gives workers a set of rights in the workplace. You can't discriminate and retaliate against those workers for exercising their legal rights. You couldn't pick up and leave because you say, gee, all the employees are women. You couldn't pick up and leave because all the employees are minorities. You don't get to discriminate against people for those reasons. But why, you know,
Reclaiming my
went through
time,
let me just
that's
for a second,
news to me.
just to give you an example. Well, we've gone through 15 years or 20 years of movement of work around the United States, much of it from the north to the south. That's all. You can do that. That's being done all the time. 70% of this airline is made out of the country. And the unions, people didn't stop those decisions.
And
in
so
this- in
reclaiming
this
my
narrow
time,
particular case.
you're hitting on exactly the challenge that I come to, because you hear it all the time. Golly, you want a good plumber, go find yourself a union plumber. You want a good electrician, go find yourself a union electrician. And what I'm hearing is that this is such a systemic problem across the country that being in a union, apparently the accusation against Boeing is, being in a union is a net negative for workers in Washington State. Because if they weren't in this union, they would have no challenge, no problem with Boeing whatsoever. But because they are in this union, Boeing has decided to pick up and move all these jobs elsewhere, understanding that's just the accusation, not what's actually happening, Mr. Scott.
Fairly torture scenario.
I don't know when that happened, but thinking about who's an American and who's not, I would tell you, for me, and I'm grateful to Mr. Scott for bringing or for drafting this resolution, it doesn't have anything to do with union workers. What it has to do with is what's the value to the company, period. And over again, the message that my friends in union states tell me is when you're in a union, you bring more value than non-union workers. And why in the world that decision doesn't carry the day is a mystery to me.
Mr. Woodall?
Well, I was going to ask you, Mr.
Yeah,
Andrews, when you were talking about Malaysia and Indonesia and moving things offshore, I'm sorry that folks have decided not to try to improve this bill, because that would be an interesting amendment to offer, that if what you want to do is leave California and come settle in the great state of Georgia, as so many folks have done in recent years, leave New Jersey, come to Georgia, we welcome you and are adopting some of your practices down there, even as we speak, for a higher quality of life, for a higher quality of life. I mean, I asked my staff, I said, how many congressional districts did Washington State have in the last decade? They said 9. I said, how many congressional districts do they have now? I said 9. I said, that's weird, because down in Georgia, we only had 11 in the last decade. Now we have 13, and we're getting ready to add one more, apparently. And I know that there's a propensity among some folks to believe they have everybody's best interest at heart and they can protect them, but apparently when left to their own devices, people decide it's all right to be in the South. We have good jobs. We just opened a new Kia plant. We opened a new Volkswagen plant. Of course, we have the Mercedes plant, the BMW plant, over and over and over again. For me, this has nothing to do with interfering in an ongoing process. It has to do with finding something that is egregious and reacting to it. This isn't some series of God-given rights that we're talking about amending. When Henry Ford was doing the good work Henry Ford was doing, which NLRB regulation required him to do that? And had he not functioned up to that high standard, which NLRB regulation would have punished him for not doing it? And the answer is there was no NLRB.
May I?
Please.
First of all, he made most of these decisions before we had a National Labor Relations.
Exactly right.
But if Mr. Ford had said, I think that the workers, let's take a real-life example. I think the workers in New Jersey are smarter and better motivated, and the quality of life is higher, so I'm going to put all my work in New Jersey and move it from Georgia, which I think would be factually supported. He would have an absolute right to do that, and he does today. What he does not have an absolute right to do is say that, well, my workers in Georgia are circulating cards to have a union election, and I don't want one. So to stop that organizing process, I'm going to shut that plant down and move it. That's what he can't do. And he hasn't been able to do that for decades under the labor law. This is not new. It's a very old and settled precedent.
Well, and I think you make an important point, Mr. Andrews, which is you're right. This is not new. And yet, like me, so many Americans were so outraged by this acting general counsel's decision that they said, we need a solution to this. I know my colleagues in South Carolina are outraged. It doesn't even affect me in Georgia. I'm outraged by it. And I think that's kind of what happens here. I'm still new, only having been here seven months. But I think that's right. So many regulations just are administered along and along and along and along until something egregious happens and folks say, golly, I just did not know that was part of the law. I'll just close, Mr. Chairman, by saying you can't love jobs and hate job creators. You just can't do it. And over and over and over again, I hear folks talk about loving jobs and talk about loving workers and escorting those jobs right overseas. The question is not how can we change the law to prevent companies from leaving. The answer is how can we change the law to make companies want to stay? And until we can agree on that direction, I think we'll continue to have these decisions, and I hope the chairman will continue to report out these bills so we can make some of these changes, and I yield back my time.
Thank you, Mr. Chairman. I appreciate it. I was listening to Mr. Woodall and my friend from Georgia said until something egregious happens, and The issue in this case is nothing egregious has yet happened. I mean, I would certainly, agree as a layperson here, not a former labor lawyer or real estate lawyer, in fact, any kind of attorney, like others in this body. I've read the popular press on this issue, and does it sound egregious that somehow the government can stop a company from moving from one state to another? Yeah, it sounds terribly egregious. If, in fact, they moved for the purpose of busting a union, I would want to know that. Again, there's plenty of valid and invalid reasons to move. I mean, the lower cost of doing business, more attractive business climate, all very valid reasons to move, but not, again, to move specifically to bust a union. So, again, I think it sounds like the most likely outcome from the process will be they're allowed to move. If somehow the process doesn't work out that way, then we should probably have a policy discussion about what the review process should be like. But, I have confidence in the process. There has been no egregious activity from it. And frankly, many of us on this committee, as well as the Congress as a whole, are somewhat of lay people in this. I mean, I doubt many of us have read the actual casework involved. I haven't. Maybe my friend from Georgia has, or maybe my friend from New Jersey has. I haven't. I've read a few articles on this, like most Americans, and have followed it. And again, it has sounded somewhat egregious. I'd like to just ask, Mr. Klein, along those lines, why preempt something that hasn't happened yet that you fear? Why not, again, while this issue is, of course, important to Washington and North Carolina, it's also important to our country as a whole. If the process doesn't work, and it doesn't work, then why not focus on fixing it? Why say it doesn't work when, in fact, it may work properly?
Well, I think, gentlemen, it's much more important than just to the folks in Washington and South Carolina, in reference to my friend from South Carolina. I am arguing that it's not the case that nothing has happened. The acting general counsel has made a ruling. It's going through the process, and the fear is palpable there that Boeing, who's already spent $1 billion and built a brand new plant and hired over 1,000 people, with plans to hire 3,000 more, we've stopped from doing that. So damage is already done, not only to Boeing, but I am also arguing across the country. Job creators across the country are looking at this and making decisions which are harmful.
Have they been stopped or delayed in making that decision?
I'm sorry?
To move. You said that they'd been stopped from building a plant. I think
They built the plant. It's already $1 billion, big, beautiful
Yeah.
building. It's already there. And now they're in danger, a real danger of not being able to use that plant, losing that $1 billion, having to fire 1,000 workers in South Carolina and prevent thousands more from being hired.
That's only if this case isn't resolved in their favor, you're saying. You're prejudging and saying if it's not resolved in their favor, this is what will happen.
But people are already making decisions.
Yeah.
Already making decisions based on the progress or process that is underway right now.
So, I mean, if a worker says that, I want a union, and they try to get the cards and they try to organize, and then the company says explicitly, because you want a union, I'm firing you and I'm subcontracting it to another company or moving it to another state, can the National Labor Relations Board order that the work be restored?
Under current law, they can, absent this bill. And under current law, and if this passes, that would still be illegal, and there are a dozen other remedies. It's been mentioned many times that there's back pay, but there are a dozen remedies that the National Labor Relations Board can use to punish the company for breaking the law.
And I'd ask Mr. Andrews, again, as many of us in this body, myself included, this is an issue that we have a lay awareness with, and I would say you've probably seen this process go through on a number of lower profile cases. Have you generally believed that this process has worked, that when there is in fact a explicit threat, the Labor Relations Board come down on that side, and when in fact it's for economic reasons, there's been no barriers to companies relocating? I mean, have you been generally happy with this process?
Yes, I think there's a reason why the labor laws have not been substantially amended since the 1950s, because they have worked. In cases where there's been overt and egregious union busting, it's a violation of law and there are appropriate remedies. This is the most appropriate remedy in this kind of case. And in cases where the employer has made a decision based upon his or her fiduciary responsibility, owners the company, and it's not motivated by animus toward unions, then the employer's had the freedom to do that. I mean, look, since the last major amendment to the labor law, we have had presidents of both parties. We have had majorities in the House and Senate of both parties And there's not been one significant amendment to the labor laws. And I think that's not simply a coincidence of gridlock politics. I think it's because the fundamental structure of collective bargaining works for the benefit of the country. Let me say one other thing, Mr. Powell, about what makes me uncomfortable about this intervention. Under the Bush Labor Board, there was a decision ratified by the courts called the Oakwood decisions. And they essentially said that a nurse who supervised essentially no one, but who once a month had to give out the assignments of who's going to give the meds to someone in a unit, became a supervisor and couldn't be in a union. And this is a situation where people who act and quacked and walked and sounded like a duck were not called a duck, that all of a sudden they couldn't be in a bargaining unit because they were supervisors. I think this was a very bad decision. We did not, during that period of time, move a bill that said that while those cases were pending in the federal courts, that we're going to redefine what supervisor means under the National Labor Relations Act. We did do a bill, by the way, which prospectively would have restored the definition of supervisor what it was for several decades. There's an important difference here, that when we had the majority and the ability to move legislation, we did have some significant proposals which would have applied prospectively, but we never interfered in a pending matter before the board or before the courts. And I think that is a very unwelcome principle, whether it's securities law, the criminal justice code, agriculture, civil rights, immigration, no matter what it is. I just think that's a very slippery slope to get on.
And in fact, Mr. Klein mentioned in his answer that the uncertainty around this is sending, signals to other businesses that are delaying decisions. Do you agree, Mr. Andrews, that in fact the precedent of congressional interference would create far more uncertainty in the marketplace than allowing the case?
Well, I do, and I think it would also invite a sort of odious form of forum shopping, where if you were sued and you lost the case at the first level in the federal district court, let's say, well, you'd come to the Congress and try to get them to put some kind of remedy or change in the law so that by the time the case is over, you'd win. And, Marbury versus Madison says that's a pretty bad idea. And I think that putting aside the merits of Boeing's decision or demerits, putting aside the issues of outsourcing, putting aside all the merits of this argument, the idea that when we're worried about the possible outcome of a certain case, we're going to take legislative action to reshape that case is a principle that I think is unwarranted under our Constitution, unwelcome under our system.
Yeah, and I would add, I think it's a very inadvisable economically as well. I mean, whatever uncertainty exists in an outcome of a particular process, the precedent of going around an existing process and coming to Congress will create far more uncertainty, not just within this particular system of labor regulation, but everywhere else where there are pending cases. And of course, uncertainty being the enemy of prosperity, I would argue that's the last thing we need now with regard to the uncertainty around the regulatory issues in our economy. And therefore, I'll be, opposing this bill. Again, I think certainly these cases should be of interest. Members of Congress should follow these cases. We should all have confidence that the system works. If it isn't working, we should try to improve it. But to try to run around the system on a pending case, I think is a very dangerous precedent for Congress to set. And I'll yield back the balance of my time.
Thank you, Mr. Chairman. Mr. Polis and I agree a lot of times on a lot of things, and I agree with your opening statement, particularly in the fact that we're not attorneys. But you get a gut reaction when you hear things, you read it in the popular press, about the ability for a board to stop a company from relocating. And it's not even relocating. It's just opening up a branch. Am I correct?
Yes, new line of business.
It's opening up another company in another state. Last time I checked, South Carolinians, I believe, are Americans. Are they not, Mr. Scott?
Yes, sir. We're still considered Americans.
That's a good thing.
Even our union members are considered Americans, while our non-union members are also considered Americans.
I just want to also mention that you have 3 union members sitting here in the front row looking at me right now. But, it's interesting about a union. My brother was a business agent, and I thought it was ironic that they had to have a union within the union to protect themselves against, I guess, a bad employer. So it isn't always about a bad employer. It's just about certain benefits that we want to talk about. But when you talk about American job growth, I think that it's commendable that Boeing would open an operation in South Carolina, because I do believe that you have an unemployment problem. Do you not, Mr. Scott?
Yes, sir, we do.
Has this helped your unemployment problem?
Yes, sir, it has. Our unemployment, if the gentleman would yield.
I will.
Our unemployment in South Carolina is at 10.5%. And the whole notion that the only way to find higher wages is to move to a state where their unions are present and dominating is inconsistent with the reality and living in an alternate universe. The reality of it is, in right-to-work states, employees make $4,400 more for the same comparable work. And the fact is that companies like Nucor Steel that operate in South Carolina, that is consistent with the steel concept and many unions in the steel industry. The fact is that the average employee at the Nucor Steel plant in South Carolina, where our average wage is around $32,000 a year, makes almost 3 times the average wage, depending on the job that you do. So the fact of the matter is that for us to try to find a way to make this a worker versus worker issue or state versus state issue is a drill down to the lowest common denominator, and is only not to politicize, but to create cultural rifts in the presence of a very fragile recovery, which in itself is questionable.
Mr. Scott, I appreciate your comment. So it's somewhat confusing that, and I understand the premise that you're worried about as it relates to Boeing, but in particular, though, Boeing has made a huge investment in America. Another portion of America may not be Washington, but Washington State, had Boeing made a decision not to increase their line, not to add another airliner, Washington State wouldn't be any the wiser, wouldn't lose anything, but it was a corporate decision on Boeing's part to increase their profitability. And the last time I checked, it's still a good idea to be profitable in America, because those that are profitable create more jobs for us in America. Coming from a district in my home county of almost 14% unemployment, we would absolutely love to have Boeing put a location in, or any other manufacturer. So it isn't about pitting one part of the country or workers against each other, because states do this all the time. They try to recruit additional businesses. Most of them are coming from another state. And so what I want to make sure is that we don't chill those companies that are looking to, A, expand, add another product line, and be forced to stay in the current situation they're in only because they're unionized. And I had been a union employee. I want to make sure that what we are doing is creating the ability in America to create more jobs. I don't care. I don't want more jobs in China or Venezuela or anywhere else. All I care about are jobs here in America. And with that, I appreciate my colleague from South Carolina. It is South Carolina. Yes, I appreciate him bringing this bill to our attention. Thank you very much.
I think I've said pretty much all that needed to be said, perhaps at the inappropriate time. But one of the things I think is very important for us to recognize is the delineation between what this is and what this is not. We've heard a lot of things from my good friends on the left about union busting. The question I'd ask myself on the union busting issue is Boeing still working and negotiating with their union members? And the answer is absolutely. South Carolina is a right-to-work state without any question, but we have union members throughout our state, to include the predecessor to the union, to the Boeing plant. The Vada Linea Partnership had a union. When Boeing took it over, they had a union. So the folks have the right today to come back and form another union if they want to. The reality of it is that this is about the remedies that the NLRB can use in order to find a way to exact a remedy that is inconsistent with reality and inconsistent with what's in the best interest of the workers of America and the companies of America. Certainly, Boeing could become a Chinese company and avoid all of the challenges that they currently have to deal with today in America. The challenge of our business environment is that, according to our own statistics, our regulations and our regulatory environment cost us about almost $2 trillion. $2 trillion out of the private sector because of our obsession with the government has the answers to everything that goes bad. That's a challenge.
Gentlemen, thank you all very much for being here. We appreciate it. This has been an interesting discussion. We'll look forward to consideration of the measure on the House floor. We are now going to proceed with consideration of S-627, the Senate amendment that will allow for consideration of the Budget Control Act of 2011. And the Rules Committee shares jurisdiction with this issue. I'm going to be talking a little bit about the proposal, and I know that Mr. Van Hollen, the ranking member of the Budget Committee, is okay. Then let me begin with my colleagues in explaining the measure that is before us. As we all know, we don't like the fact that we're here, and we are over the past several weeks and months. There has been a lengthy discussion about the imperative of increasing the national debt. We know that our Democratic colleagues had called for, and we had a floor vote on a so-called clean increase, meaning an increase in the debt ceiling that would not have anything attached to it whatsoever. We felt very strongly that it was important for us to recognize that this was our opportunity to change the trajectory that we had been on for the last 4 years. As everyone knows, we've witnessed an 82% increase in non-defense discretionary spending over the past 4 years, and as we focus on job creation and economic growth, something we've just been talking about, something that the American people repeatedly say to all of us, Democrat and Republican alike, we feel very strongly that it is essential that we seize this opportunity, recognizing that it is important for us to pay our obligations, to meet our obligations, which is what the increase in the debt ceiling will call for. But we wanted to seize this opportunity to change the trajectory on which we've been on for the past several years. There have been many discussions. We heard last night from the President of the United States and the Speaker of the House. And what we have before us today, and what we've been considering on the House floor, it was filed last night to comply with a 3-day layover requirement. What we have before us is a bipartisan measure that was agreed to by the Speaker of the House and the Senate Majority Leader, Harry Reid. And this is an agreement that they came to over this past weekend. And we all know that there have been changes that have been made on the position. Mr. Reid is not, at this juncture, supportive of the measure which he negotiated with Speaker Boehner. But we are proceeding with consideration of it here. And as I said, no one is happy about this, but we believe that the action that we are going to take here will go a long way toward, again, changing the direction on which we've been on. And so I'd like to take just a few minutes, if I might, to explain the provision that is before us. It's described as the Budget Control Act. It has 3 defining components. First, it conditions any increase of the debt ceiling on the implementation of spending cuts, spending reductions larger than the requested increase in the debt ceiling. And the cuts must come before any increase in the debt ceiling is put into place. Second, it requires the consideration of a balanced budget amendment in both the House and the Senate. It calls for debate and a vote in both houses of Congress on a balanced budget amendment to the Constitution. Third, it establishes a joint select committee tasked with finding real savings. It also provides an up or down vote on the joint select committee's work product. It requires an up or down vote in this institution and in the Senate on that. First, as I said, the measure reduces discretionary spending by $1.2 trillion over 10 years. It requires that these reductions pass both the House and the Senate and be signed by the President before any increase in the debt ceiling actually occurs. Once the initial cuts are agreed to, a temporary increase in the debt ceiling will be granted. This will allow Congress to begin the process of disapproval of the next increase. In September, both the House and the Senate will consider resolutions of disapproval of the next increase in the debt ceiling. The President will veto that measure, and the House and Senate will have a vote on overriding that veto. Failing a veto override, an increase of $500 billion will be granted. Also in September, the Joint Select Committee will begin its work to identify another $1.6 trillion in savings. Now, as we've all read, this Joint Select Committee will consist of a 12-member panel that will be appointed by the House Speaker and the Minority Leader, and the Senate Majority Leader and the Senate Minority Leader, 3 each appointed by the 4 leaders of the 2 houses of Congress. The legislation provides standing committees with an opportunity to provide input on how to achieve those savings. So in many ways, this is like the Base Realignment and Closure Commission that was put into place a decade and a half ago. It requires the Joint Select Committee product to produce a work product by November 23rd of this year. It would have to file its final legislative product in the House and Senate by December 2nd of this year, and after which that product that has come from the Joint Select Committee will be introduced as a bill. The Joint Committee's bill would be debatable in the House for 2 hours and would not be subject to amendment. So this is the expedited procedure we allow, so that the work product of the Joint Committee will have a clean up or down vote. In the Senate, the bill would likewise not be amendable and would need a simple majority vote for passage. The bill requires action in both chambers by December 23rd of 2011. If action is not taken or the President does not sign the legislation approved by the Congress, there will be no further increase in the debt ceiling. Now, I should also say that the rule that is going to be before us will provide for consideration of the Budget Control Act, along with a few extra provisions that need to be done as we move ahead. We will do something that has not been done before. We're going to extend suspension. Excuse me? Yeah. Well, what we're going to be doing, Ms. Slaughter, is we are going to provide the minority with the opportunity to see any measure that will be considered under suspension of the rules 1 day before it is debated on the House floor. In the past, under both political parties, we have seen measures offered with 1 hour's notice before they're voted on the House floor. So what we're going to do is something that has not been done before. And if you object, it'll be interesting to hear. We are going to, let me just finish if I might. We are going to provide the minority with an opportunity to have 1 day's notice on any measure that we will consider under suspension of the rules as we proceed with consideration of, with the allowance of suspension authority through this coming Sunday, July 31st. So we won't bring up anything under suspension of the rules without giving 1 day's notice. And we'll also be, in the rule, have various housekeeping measures related to the House being in session in August, and this will be necessary because of our inability to pass a joint adjournment resolution. With that, I'd like to call on my other... If I might, I'd like to call on the other witness, because I have just offered this. I'd like to recognize the ranking member of the Budget Committee, Mr. Van Hollen.
I have a point of parliamentary inquiry, Mr. Chairman. Mr. Chair, I have a point of inquiry. Okay.
Mrs. Slaughter.
Yeah. Mr. Dreyer, I distinctly heard you say that this bill is a bipartisan bill and an agreed-upon bill between Senator Reid.
Well, if I could reclaim my time, if the gentleman would yield, would the gentleman yield? I thank my friend for yielding.
Clear that up.
Yeah. Well, I'd like to make this clear. Over the past week, we do know that over the weekend there were meetings that took place among the 4 top leaders of the 2 houses of Congress: Speaker John Boehner, Minority Leader Nancy Pelosi, and the 2 leaders of the Senate, Mitch McConnell and Harry Reid. And there was an agreement based on the reports that have come forward from Speaker Boehner between the Speaker of the House and the Majority Leader of the United States Senate. Now, if I said that after that agreement took place, there was a change in the position.
You didn't say that at all. You still left it as a bipartisan
Elsie,
bill.
excuse me,
But-
if I might, Elsie Hastings just confirms that I did say that, and we will, if we'll go back and look, that's one of the reasons we're glad to have cameras here. Yes, I did.
Yesterday, you said to me that there was an agreement, and I
single bill.
indicated to you that there
Well,
was not.
As a matter of fact.
if I might, let me just say, so Mr. Hastings confirmed that I did in fact say that, Mrs. Slaughter, so I just want to say that there was an agreement, and I made it very clear that the agreement does not exist at this moment because of a meeting that took place with President Obama.
Not make
and
that clear in your opening statement. It's
Yes,
certainly
I did.
not to me.
Well, you may have been out of the room. You may have been out of the room when I made the
No,
opening
I was
statement.
sitting
Mr.
right
Hastings
here
heard me say it.
and heard you
So what
say
I'd like to
that
do,
it's
okay,
Bill.
okay.
Look, let me
If I did not say that, if I did not say that,
Let me
that,
reclaim
Hold on
my.
and let the reporter gather what you all are saying.
thank you very much, Mr.
Well, I
Hastings.
simply want to say,
Ms.
not
Slaughter.
only is it not an agreed-upon bill, Senator Reid is going to hold his vote off until Thursday to see what happens here. Then his bill will be the only one left in town should it fail in the House. Now, I don't believe that Senator Reid, nor do I believe that Speaker Boehner have any idea that they are putting forth a bipartisan bill on which the two of them have agreed. And I want to make that perfectly
Well,
clear
let me just
for
say,
the record.
thank you very much, Mrs. Slaughter, and let me just say, I will reiterate what I said in my opening statement. I will reiterate, as Mr. Hastings has confirmed, what I said in my opening statement. Last weekend, there was a bipartisan agreement that put this package together that we have before us. And I said, that changed at the end of the weekend. That changed at the end of the weekend. And so I'm simply reiterating what I said in my opening remarks, and with that I'd like to call on Mr. Van Hollen for his testimony.
Mr. Chair, point of parliamentary inquiry. It's brief.
Mr. Polis.
Thank you. The bill that we have, amendment in the nature of a substitute to Senate Bill 627, the version I have is blank as to who it's offered by. Does the bill have a sponsor, and if so, who's the
No, this is a Senate amendment that we're considering. There is not an author. This is the agreed upon package that was put together by the Speaker of the House of Representatives and the Majority Leader of the United States Senate, Mr. Reid.
So there's no House sponsor for it?
This is a Senate amendment that we're considering, and this is the agreed-upon package that was put together. It's a Senate bill that we have before us that we're amending.
Who's the sponsor of the amendment?
Well, this is the agreed-upon deal. There's not a sponsor to the amendment that we have before us. This is the Speaker of the House of Representatives, as I said. The Speaker of the House of Representatives, as we've all seen because of all the coverage that has taken place, has been working over the past days and weeks to put this agreement together.
Just a quick follow-up. Again, amendment in the nature of a substitute offered by M. Blank. When, and I believe as a point of procedure, an amendment in the nature of substitute would have to be offered by a member of the House to a Senate bill.
The Rules Committee has jurisdiction on this, and we will be making a determination from the Rules Committee when we proceed with this.
Meaning we'll have, the Rules Committee will be the sponsor of the amendment?
Well, I mean, I will be managing this on the House floor, and so in light of that, when we proceed with consideration of this.
We can call it the Dreyer Bill?
You're welcome to call it whatever you'd like. You're welcome to call it whatever you'd
Further
like.
parliamentary
Again, this is a
inquiry.
Senate bill we're considering.
Further
Yeah, well, Mr.
parliamentary
Polis,
inquiry.
anything further?
That's all for me. Thank you.
Thank you.
Further
Mr.
parliamentary
Hastings.
inquiry. Can the Senate offer a measure in the House of Representatives?
What we're doing is we're taking up a Senate bill here in the House of Representatives,
Yeah, but
offering an amendment to that bill.
But
This
a
is the Freedom
House
of Information
member, am I correct, Mr. Chairman, that a House member must offer a measure in order for it to be taken up by the House?
This is a Senate bill that has come forward. The Rules Committee has this. It's come from the Speaker of the House of Representatives, and we are considering it under that structure. And we're going to proceed. As I said, this is original jurisdiction for the Committee on Rules. That's the reason I outlined the provisions of the agreement that, again, last weekend had the support of Senator Reid. It does not any longer, but it did last weekend.
I hear you, Mr. Chairman, but I think that it is, in all due respect, false to say that there was an agreement. There was discussion by those persons with whom you have identified.
Let me just say what I'm basing this on. I'm basing this on what the Speaker of the House of Representatives, the Speaker of the whole House, has indicated was an agreement between the Senate Majority Leader and the Speaker of the House of Representatives. And, as I said, that changed. I acknowledge that that changed. But we are where we are today, and I'd now like to recognize Mr. Van Hollen. And any prepared statement that you have will appear in the record, and we welcome your summary.
Thank you, Mr. Chairman, Ranking Member Slaughter, members of the committee. Thank you for the opportunity to testify on the amendment in the nature of a substitute to S627. Mr. Chairman, I can understand, having read this, why no one wants to claim parentage, and let me go into some detail on that issue. And I urge the committee not to send this particular rule with this, making these in order to the floor for the following reasons. This proposal would play Russian roulette with our economy every 6 months. We know what a dire situation we're in right now. The clock is ticking. We've heard not just from Secretary Geithner and the Chairman of the Federal Reserve, Ben Bernanke, but by independent bond rating agencies, Standard & Poor's, Moody's, others, that if we do not make sure that the United States pays its bills on time, beginning April 5th, that we will put the creditworthy United States at risk, and that will risk rising interest rates across the board, which would be a huge hit on every American. So we all want to try and resolve the issue. The question is, why would we have a proposed solution that puts us in exactly the same place 6 months from now? And everybody needs to understand that is a choice this body's making. We don't have to make that choice. We don't have to choose to say we're going to put the economy in jeopardy 6 months from now. And that is the fundamental flaw with this particular piece of legislation. Now, Senator Reid's name was mentioned. As I'm sure all of us are aware, Senator Reid has a proposal that's on the table. It would, according to CBO scoring, achieve $2.7 trillion in savings off the baseline. $1.2 trillion of that are based on caps to discretionary spending, the same cap with respect to discretionary spending that is in the proposal before us. The main difference being that the proposal put forward by Senator Reid doesn't put the U.S. economy in jeopardy every 6 months and doesn't put us through this situation that we're going through right now. If I could, so that is the fundamental issue with the bill before us. There are lots of other issues, but for clarification, Mr. Chairman, I'd like to understand, is the rule also going to envision putting a proposed constitutional amendment in order under suspension?
What we're looking to do is to extend the debate time so that we will be able to consider under suspension of the rules a balanced budget amendment to the Constitution.
Right. So we would bring a balanced budget amendment to the Constitution up under suspension of the rules.
Right.
Right.
That's the plan, and to do that after we consider this measure on the floor.
And I take it that because it's up under suspension, it would be not open to amendment. Is that right?
That's correct.
Okay.
And but what we're looking to do, and the reason we're including this in the rule, is so that members on both sides of the issue will have an opportunity to speak. So we're looking to extend the debate time. That's the only provision we'll make beyond having it measure considered under suspension of the rules.
Thank you, Mr. Chairman. In that case, I'd just like to make a few points about that particular provision in the rule.
Okay.
And we went over this in some detail before, but I think it's worth revisiting, that this is no ordinary garden variety balanced budget amendment. What it really does is manipulate the Constitution, bias it in a way to plant the Republican budget proposal into the Constitution. Why do I say that? There are two provisions that do exactly that. Number one is the provision that says that you only need a majority vote to cut Medicare, a majority vote to cut education, a majority vote to cut Social Security, but you need a two-thirds vote to cut special interest tax breaks for the purpose of deficit reduction. It is undeniable that you are writing that bias into the Constitution. And for the last week, I've heard no justification for why we would do that. Why would you not allow the American people through the Congress to work their will in that way and put a constitutional obstruction that biases us in favor of cuts to education and Medicare, but not cutting special interest tax breaks for the purposes of deficit reduction? You want to put that in the Constitution. Second provision. Second provision is an 18% expenditure cap. Now, we should all understand that we have not met that expenditure cap since about the time Medicare was passed, because this country decided that it was worth providing some health security to people in their old age. And so since the mid-1960s, we have not had that level of expenditure. We've been higher. When you cap expenditures at that level, what you are doing is ensuring cuts to things like Medicare and Social Security. That's going to drive that. Again, you want to plant that in the Constitution of the United States, not allow the majority to work its will. And the irony is this. The last time we had a budget that was in surplus, was during the Clinton years. During the Clinton years, we had a budget in surplus. We had projected, we had a $10 trillion projected surplus at that time. No deficit spending, nothing. Under this twisted version of the constitutional amendment, that would have been unconstitutional. That surplus budget would have been unconstitutional because it was at 19% expenditures, not 18%. So under the mantle of fiscal conservatism, you want to implant in the Constitution of the United States a provision that would have made the last budget that was in surplus unconstitutional. I mean, that is just upside down logic. The last question I have is this amendment, Mr. Chairman, this constitutional amendment seems to have changed since the one from last week. There's another provision in here. I don't know if you want to explain it or you want me to comment on it because I find it very curious.
Let me just say that obviously, as I told Mrs. Slaughter, we're going to do something in this rule that has not been done before. We're going to guarantee the minority. We're going to guarantee the minority the right to see a bill considered under suspension of the rules one day before it is submitted. And so you're certainly welcome to comment on any balanced budget amendment or proposals that you've seen. I'm aware that we've posted the balanced budget amendment, spending limitation amendment on the site as of today. But as you know, there's a possibility. So if you'd like to comment on,
well, I just maybe the sponsors of the amendment, whoever they may be, can comment on this significant change to the Constitution of the United States regarding expending money when the United States is undergoing military operations.
Mr. Chair, I thought this was a drier bill.
Yeah, I'd like to hear.
If I might, I'm talking about the agreement was put together. It's a completely separate matter, the consideration of a balanced budget amendment this week. We're talking about this rule will allow for extension of debate time under a measure considered under suspension of the rules that we would have as it relates to a balanced budget amendment to the Constitution.
Will the gentleman yield just for a question?
Well, let me just, this is somewhat unusual right here. I've just outlined this measure. I wanted to hear from Mr. Van Hollen, and then we'll have an opportunity for everyone. We're going to have an opportunity for everyone to do that. So, Mr. Van Hollen, are you completed with your testimony?
Well, I'm really not trying to put you in a tough situation, Mr. Chairman.
Well, I mean, I'm trying to figure out what testifying on your view of the measure that we have before us.
Well, I'm just trying to figure out exactly what measure we have before us.
Right.
So I'm wondering if
I outlined the Budget Control Act, and the only thing that is in this rule is it allows for the possibility of consideration of a balanced budget amendment later this week. All we're doing in this rule is extending the debate time so that members of the minority and the majority will have an opportunity to consider an item that is considered beyond the purview of this Rules Committee. It's an item that will be considered under suspension of the rules.
Mr. Chairman,
and so that's
just so I understand, we have no idea what changes to the Constitution the United States Congress is expected to vote on by Wednesday.
That clearly will be submitted for the record, and there will be an opportunity to debate that on the House floor. The gentleman like me to yield?
Yes, please, if you could.
I'm happy to yield, my friend.
I'm just curious. The balanced budget amendment that we're talking about, is that the one that was printed on is the one printed on the Rules Committee website the one that we're going to be considering? Just so we're all clear on what we're talking about.
Well, let me just say that we will have one day before debating this, we will have it made available. Yes, we have placed that one on the website, but as I said in response to Mrs. Slaughter saying that we've done things that are unusual, we're going to do something that is unusual. We're going to provide that one day before it's considered on the floor under suspension of the rules.
But the one printed.
And so what I will say is that you will have an opportunity to see that one day before we consider it.
The one printed on the Rules Committee website.
It may or may not be. We're going to provide it one day before consideration.
And we're talking about amending the Constitution of the United States of America.
One day notice.
One day notice. I thank you. Thank you for your
Mr. Chairman, just on that point, and I understand how you're saying that it's unusual for the majority to present something on the suspension calendar more than 24 hours' notice. This is not just any ordinary bill, as you know. This is the Constitution of the United States. And I would ask, I don't know the answer to this, whether the amendments to the Constitution of the United States have been taken up in the past under suspension of the rules, because the
answer is yes. There have been a number of times that there have been votes handled because a two-thirds requirement is there, and I can't tell you exactly which occasions, but we can certainly find that out. But as we know, there are a number of proposals that are out there, and we will have an opportunity to see those made available one day before the vote does in fact take place.
All right. Well, I'll just end then based on make one comment based on what appears to be on the website. So yes, I do have some concerns about changing the Constitution in a way that fundamentally alters the war powers resolutions and what kind of commitments that we make to our troops in terms of funding wars or military decisions that we undertake as a country. And we'll have
Thank you very much, Mr. Van Hollen. Mr. Sessions.
Thank you, Mr. Chairman. I want to thank Mr. Van Hollen for not only appearing for the committee today, but I also want to thank you, Mr. Chairman, for outlining the copy of the agreement, which does not exist today, as the actual agreement. What I would like to say is that the country is watching what we're doing. And with great anticipation, I believe that Speaker Boehner and Majority Leader Reid are attempting to, within their own bodies, work through what I believe is a very important agreement as a result of the President of the United States not being able to sustain his ideas that he has given to a point of legislation. I think it's important that we remember that the American people are watching what we're doing. I think it's important that the American people know that this legislation is in print, is on a website before the Rules Committee, that everybody in America that chooses to can go and take a look at the words. There will be a full debate, and whether it's perfect or not is not the issue. It is an agreement between two constitutional bodies, the House of Representatives and the Senate, and I believe that that is real leadership. I think it's leadership by Senate Majority Leader and by Speaker Boehner. So it's my hope that you will get an opportunity that I think we've allowed, including unprecedented ability to see whatever we're going to present to you forthrightly, that the American people can then judge. So as best I can tell you, whether it's called the Dreyer Bill or the agreement, I think it's a good thing that the American people see that we're here serious about doing our job in business and wish to avoid further delay so that the American people can know that we will not leave until this is done. And I'm sure you agree with that, Chris, every bit of it. So
I agree. We need to get something done.
we need to get it done.
Ms. Slaughter.
Yield back.
Mr. Van Hollen, how surprised do you think that Senator Reid would be to understand that we're voting his bill today, that there's an agreement that he has with Mr. Boehner?
Well, I think we're going to have to ask him, but given the fact that he's put his own proposal on the table that's very different, I think the question answers itself.
Exactly, and the reason that, if I could just say this one more thing, the reason that I bring that up is continuously told to us that this is an agreement between the Speaker and the Majority Leader. It is not.
Would the gentleman
And it's the most frustrating thing in the world. If we can't even agree on that one truth, I would have to
I thank my friend for yielding. And let me just say once again what I said in my opening statement and what Mr. Sessions had indicated. This was an agreement that the Speaker of the House and the Senate Majority Leader came to last weekend. It came to an end.
It isn't now.
No one ever said that it's an agreement now. No one has ever said that this is an agreement now. It was an agreement, and what Mr. Sessions was just saying is that he knows that Mr. Reed is also working on his agreement, and he's no longer a part of the agreement that existed last weekend. And I just think it's important for you to understand that no one has said, Mrs. Slaughter, that this is an agreement today.
Well, let me.
I thank my friend for yielding.
Thank you. You're very welcome. Mr. Van Hollen, I think the American people are watching. The calls to, I have 3 district offices in the Washington office. Really pretty much been off the phone today. People are terrified. I can't for the life of me understand why we would try to rile up the markets again by doing this again in 6 months. I mean, how could we possibly get anything in order? How could we have any economic stability in this country without hanging? Look how hard it is now. How hard do you think it'll be 6 months from now? But to change the Constitution under suspension, you were about to mention something that I've talked about with my staff about what happens to the military in this constitutional change. Would you elaborate on that?
Certainly, Ranking Member Slaughter.
Because it's really a beauty.
And again, I do find it concerning, to say the least, that we would be talking about an amendment to the United States Constitution, our founding document, and even as we gather here today, we apparently don't know exactly what's going to be on it. We do know what's on the website as proposed, and on that provision, which is planning to be brought to the floor, which is my understanding, is a provision that would allow a majority vote to pass a resolution to use force to send American men and women into battle. But if you want to pay for those, pay to support those troops, you can only do it if the underlying vote for use of force was a 3/5 vote, which is staggering because, as you know, Ranking Member Slaughter, a majority vote can send American soldiers into battle. In fact, it was a majority vote, not a 3/5 vote, on the Persian Gulf War. There was the Korean War, there was no resolution, actually. There are a number of conflicts where we've had military men and women in harm's way that were not originally passed by a majority vote, and yet this proposed constitutional amendment that appears on the website would say, unless you had a 3/5 vote to send men and women to the Persian Gulf, unless they're a 3/5 vote, we're not going to pay for them. Send them off to war under constitutionally authorized procedures, but unless there's a 3/5 vote, forget it. Under this constitutional amendment, you cannot go into debt if it means paying for those troops. In other words, you can't borrow a penny unless it means because it would violate, and let's just be very clear, World War II, for example, we borrowed a lot of money. We as a country borrowed a lot of money to make sure we fought and won that war. The provision on the website would prohibit you from doing that, even though there was a legally authorized vote by the Congress to send those men and women into battle.
It boggles the mind. And of course, we've already been told that even though the constitutional amendment is on the website, it will be changed. And as I understand it, Mr. Boehner said that there would be no vote at all on balanced budget amendment until after September 30th. Are you aware of that?
I know that as part of his proposal, he says the vote would take place sometime, I think, after October 1st, but before the end of the year. It would take place in that time frame, yeah.
Well, as I said,
which of course, we passed this legislation last week that said unless we pass a constitutional amendment by August 5th, we won't pay our bills. Mm-hmm. And now the Speaker's got another proposal saying let's pass it, let's have a vote on it sometime between October and the end of the year. I don't know what the Rules Committee would control when the vote comes up.
It's pretty difficult to follow the bouncing ball. Thank you very much.
Thank you.
Ms. Fox.
Thank you, Mr. Chairman. I agree with what Mr. Sessions said earlier about the American people are watching very closely what's happening here. And as I say to my constituents in letters that I write them and speak to them, that the best thing that has happened about the problems and challenges that we're facing right now is that the American people are paying close attention. That for the first time they're engaged in looking at what does it mean to raise the debt ceiling? How much in debt are we in this country? What is our deficit? Unfortunately, they're not always getting the full picture from the media or from our colleagues in terms of the situation that we're facing. But it is a dire situation, and I know this will be the most important vote that I will take since I have come to the Congress, and I think most of my colleagues feel very strongly about it, that that is the case. And I think that it is very important that we continue to emphasize that this is not about next year's election, but this is truly about the future of this country. Do we care about this country? Do we want to see it continue as the greatest country in the world with the greatest potential of any country in the world? Or do we want to see it be taken down by the people who have put us in this position in the last 4 years with their reckless spending and their disregard for the principles that have made us such a great country? And I hope that that's what people are going to understand, that there are some real principles involved here, and that the challenges and the way we answer those challenges won't have to do, well, there'll be a choice. Do we want to do this based on our own personal desires and our own personal goals and egos, or are we looking for the good of the country? And I know that I'm going to be looking for the good of the country and the future of this country, and I hope that most of my colleagues are going to do that too. Thank you, Mr. Chairman.
Mr. Governor.
I hope the people are watching. I really do. I pray that the American people are watching and watching this process, which is an outrage. You're talking about amending the Constitution of the United States, and we're told that what's printed on the Rules Committee web page may or may not be what we vote on. But we'll give you something a day in advance that you cannot amend. Amending the Constitution of the United States of America. And it gets even more confusing. My colleague, the ranking member, Mr. Slaughter, pointed out that in the text of the Boehner resolution, I guess it's Dry or Boehner, whatever, he says that there will be vote on a balanced budget amendment after September 30th, 2011, and not later than December 31st, 2011. The House and Senate will vote on a balanced budget. So we're going to have a balanced budget amendment vote this week. We had one already, and then we'll do another balanced budget amendment vote in between September and December. I mean, this is it's a sloppy process on a very, very serious issue. And when it comes to amending the Constitution, we need to proceed with great caution. But this is like we're throwing all kinds of paper at everybody. And as you mentioned, the balanced budget amendment that was originally reported out is different from the one that's on the Rules Committee webpage. And again, it makes it more difficult in times of war if we exceed the cap to be able to fund our troops. But somebody made a conscious decision to change the word majority to 3/5. Yeah. I don't know why, and nobody is here to explain that. I mean, the chairman of the Budget Committee ought to be here, or whoever's responsible for some of this stuff ought to be here. I want to know in the Boehner proposal, what it means, what it means to real people in this country. I mean, there are draconian cuts. We're talking about bringing federal spending back to a percentage of GDP at 1966 levels. What does that mean? What does that mean? Where are these cuts going to be made? And as you pointed out, Mr. Van Hollen, there's just something wrong when a hedge fund manager pays a lower tax rate than his secretary. Yeah. And we can't we're unable to fix that. Somehow that's okay. And it is, people are willing to sacrifice in this country, but it needs to be fair. And all the fairness is gone. This document, this bill that is being brought before the Rules Committee, the Dreyer-Boehner bill, is, quite frankly, worse than the Ryan budget. And that was pretty bad. And there are serious implications to some of the cutbacks that we're talking about. I want to know how many jobs are going to be lost as a result of these cutbacks. Can anyone know the answer to that? Do you have any guesstimate of if we follow this path, what it would mean in terms of job loss?
I do know that the chairman of the Federal Reserve, Ben Bernanke, testified within the last couple weeks that any significant cut in terms of the investment the federal government makes at this particular moment when the economy is so fragile would lead to job losses. In addition, the Senate for Budget and Policy Priorities has estimated that if you adopt the Republican budget plan, that 700,000 jobs would be lost. The challenge all along has been to do two things at the same time. Number one, make sure that we do nothing in the short term to jeopardize the very fragile recovery. And very steep drops in investment will do that. For example, the transportation bill that's coming out of the Infrastructure Committee cuts our investment in transportation by 35% compared to last year's level at a time that you have 20% unemployment in the construction industry. So that obviously hurts the economy badly. At the same time, we need to put together a long-term plan to reduce the deficit. And the President has put forward a proposal that would do that in a balanced way. We've talked about that before in the committee. The President talked about it again last night. And as you indicated, Mr. McGovern, one of the key differences is that the President believes, and I believe, and I think most of us on the Democratic side believe, that we should be making the tough choices in terms of cuts, and his proposal does that, but we should also be cutting some of these subsidies for big corporations for the purposes of deficit reduction, which is why it's very troubling to see a provision that would enshrine in the Constitution of the United States a preference for cutting education and Medicare over cutting special interest tax breaks. Again, a majority vote to cut education and Medicare, two-thirds to cut special interest tax breaks for the purpose of deficit reduction.
It's unbelievable when you think about it. You mentioned Robert Greenstein from the Center on Budget and Policy Priorities, and he issued a statement saying that this plan, the Boehner plan, is tantamount to a form of class warfare. He says, if enacted, it could well produce the greatest increase in poverty and hardship produced by any law in modern U.S. history. I ask unanimous consent to insert Mr. Greenstein's. I mean, there are people behind these cuts, and again, the cuts seem so disproportionately aimed at those who least can afford it. What is the impact of the Boehner plan on Social Security and Medicare? What does that mean? I mean, if this were to become the law of the land, what would that mean for Social Security and Medicare beneficiaries?
Well, what's very what's troubling about the Boehner plan is it makes it appear that everything will be painless, when in reality it will be incredibly painful. Two important safety net programs like Medicare, like Social Security. And the reason for that is if you artificially cap all expenditures at the level they're talking about, implanting in the Constitution of the United States, at a level that we have not achieved since the time we enacted Medicare, you are going to force those kind of changes. And we know that those are the kind of changes that they're anticipating because we have the budget that passed the House originally, which CBO has looked at. And under that proposal, seniors would be forced out of the current Medicare system. They'd be forced into the private insurance market, where, according to CBO analysis, they get hit with a double whammy. Number one, costs are higher in the private insurance sector, and so they'd have to eat those costs, but the support they're getting from what would be called the remaining Medicare program would be a whole lot less than they're getting right now. Right now, you know, a Medicare recipient in the year 2030 is anticipated to get about between 70 and 75% support the Medicare program. Their proposal would cut that from 75% support to about 25% support. I would just point out that members of Congress in law have 75%. So under their proposal, they'd be giving seniors, future seniors on Medicare, a much, much worse deal than they would give to members of Congress.
I mean, I think that, you know, as we're talking about this issue of not only raising the debt ceiling, but how we get our debt under control, I think it would have been helpful to have your counterpart on the Budget Committee here, or somebody who could kind of explain to us, you know, how they anticipate these cuts being implemented. And I want to just take issue with something Dr. Fox said. She mentioned the last 4 years of irresponsible spending. I want to submit to the record a Bloomberg story entitled "Republican Leaders Voted for U.S. Debt Drivers," and a chart that appeared in the New York Times that showed the expenditures of President Bush and of President Obama. And I, you know, want to inform my colleagues here that the costs of the war in Iraq and Afghanistan that are not paid for, because somehow we believe we can go to war and nobody has to pay for it, coupled with the Bush tax cuts, far outpace anything. And that's before we get into the non-defense discretionary spending of President Bush, the TARP, the Medicare drug prescription bill, and so on. But just the war costs and the tax cuts alone, what they account for in terms of our debt. And to suggest that the way you get out of this debt is to pile all this burden on middle-income families, on senior citizens, on the most vulnerable, is just plain wrong. This is outrageous. And again, the process is outrageous. I'll just close with this. I mean, people are angry out there. They're angry that the House of Representatives appears to be intransigent. That it's, you know, the Republican leadership in the House's way or no way at all. And you know, President Obama has put a lot on the table. And I'm going to be honest with you, he's put some stuff on the table that makes me feel very uncomfortable. But he has gone the extra mile, I think, by any objective analysis. And here we are, close to this deadline, and what comes to the floor is something that doesn't represent a compromise. It goes so far to the right, it goes right off a cliff. And we shouldn't be doing this right now. We should be trying to find ways to come together and to find out what we can agree upon, and let's move on. But I regret that we're here, and I think that this process, especially when it comes to amending the Constitution of the United States, we don't even know what the hell you're going to bring to the floor. I've never experienced anything like this before, and I really regret that we're here, and I thank you very much for being here. I wish your counterpart were here. Thank you.
Thank you, Mr. Chairman.
Thank you very much, Mr. Chairman. Mr. Van Hollen, how many hearings has this bill received?
To my knowledge, there have been none prior to this hearing now.
And that being none means that
As in
no
zero.
witnesses, no experts, or anyone have testified regarding this matter.
That's correct.
Has the Budget Committee or the Ways and Means Committee met to mark up this bill?
No, Mr. Hastings, neither of those committees has marked up.
And please tell me, because I've listened to you and I think you have been an exceptionally reasonable voice, and I might add, in many respects, working with your colleagues, I'm always pleased when you and Mr. Ryan do come here together, or when the two of you are in active discussions, be it in the media or in your respective capacities as leaders in your caucus and conference. But tell me the implications, if you will, of the Ryan budget and the measure that we are addressing at this time.
Well, Mr. Hastings, first of all, Mr. Ryan and I both do share the goal of trying to reduce our deficit in a predictable, steady way and get the job done. We obviously have very different views on how to do it, but I'm pleased that we have a good working relationship. The connection between the provisions that are being put forth today and the budget that passed the House that was authored by Mr. Ryan is this, that if you look at the proposed constitutional amendment, and again, this is why it's disconcerting that less than 36 hours out we don't have the exact provision they're proposing. But if you accept that the one that they've got on their website, which is the one that passed the Judiciary Committee, is what they call the balanced budget amendment that they're proposing, it would actually be like the Republican budget on steroids, because it would require that you adopt the budget put forward by the Republican study group. In fact, even that budget doesn't hit the targets in their proposed constitutional amendment within the time frame called for. So, Mr. Hastings, to answer your question, as bad as the House Republican budget was in terms of the hit on Medicare, the deep cuts it would call for in education, the deep cuts in critical investments in this country, and what it would do to Medicaid and the seniors and disabled individuals who depend on that, as bad as that would be, the constitutional provisions they're talking about inserting in the Constitution would be even worse. And I would just remind my colleagues as we talk about this that the House Republican budget, the one that passed, would require that you lift the debt ceiling by $8 trillion between now and 2021. So let's all recognize that this is a difficult challenge. We should do it in a balanced way, but recognize at the same time the point that Mr. McGovern was making, which is the reason we have to lift the debt ceiling now is because of votes and decisions that this Congress made in the past. And he identified the major policy drivers. The major driver right now is the economy being slow. And I do sympathize with some of our newer members. They were not here to vote on those wars. They were not here to vote on the Part D prescription drug bill that went on our credit card. And they weren't here to vote on the back-to-back tax cuts in 2001, 2003. But those, if you look at any CBO analysis, are the major policy drivers of why we're in the particular predicament we are today. Now, going forward, we have all the other challenges we've talked about, health care security, retirement security, but right now it's time for us to take responsibility for the collective decisions our country has made.
I thoroughly agree with you. The chart that Mr. McGovern entered into the record points out the total cost of new policies during President Bush's administration was $5.7 trillion. And to date, the total cost of new policies under President Obama's administration is $1.44 trillion. If you don't mind at this time, Mr. Van Hollen, I'd like to depart from querying you to a quote from the President's remarks last night. I thought he and Speaker Boehner were both very clear about their respective positions. I passed out and will give to my Republican colleagues at another point in time, just for levity, a cartoon that appeared that said that Mr. Boehner's two-step program is step one is my way, step two is the highway. But more significantly, there's something in this legislation that really does need to be paid attention to, and that is the ducking of our responsibilities as members of Congress. meaning the House and the United States Senate, and passing it off as if something is happening to some magical commission that's going to be constituted of 12 persons from the House and the Senate. And here's what bothers me about it. Number one, it's going to be constituted in a similar manner as the Joint Economic Committee. And I have confidence that the Joint Economic Committee has served an extremely important function for us. But here's what the Joint Economic Committee costs, and it says distinctly in this language that's in this measure that it will follow its formulation in the same manner as the Joint Economic Committee. Well, for the benefit of my fiscal conservative friends, the Joint Economic Committee cost $4.2 million in fiscal year 12 appropriations, $4.8 million last year, and has a staff of 40. Now look at here, y'all. I didn't get elected to come up here and have some commission with something that's notional at best come back to us before December of 11 and say to us that I got to vote up or down with no amendments, 2 hours of debate. What you 12 people have decided is what we should be cutting from this budget. And I don't have any way of going about representing my constituents if I'm not in that 12 and saying what my overall feeling is regarding what we should cut. That is extremely dangerous. In addition to the fact, what it is doing is passing off our responsibility as if we are doing something. And the people in this great country looking at this, and I join Mr. McGovern and everybody else that says that I hope the American people are looking, the people looking at this would have to know that, number one, we didn't get into this mess overnight, and we're not going to get out of it overnight. We didn't get into this in the last decade. I get so tired of hearing each of us point back to who caused whatever it is that we're in right now. We all know how we got here. We all know that over the 30 years that just passed, that we transitioned into a global economy. We all know that technology is impacting the living daylights out of us by causing immensely wonderful efficiencies and at the very same time causing people to make less money and to have less jobs. We all know that for whatever reason in globalization, that many of our jobs were transferred and are being transferred offshore. We all know that we're not manufacturing anything of any consequence. And we all know that right now a new normal is upon us and that things ain't going to get better no time soon. They're very likely to remain the same. And here we are, all of us, going down there getting ready to vote to create a commission. How many commissions have we created? We had Simpson-Bowles. All President Obama had to do was come out, in my judgment, and say, let's just do all we can under Simpson and Bowles and put it back out here. Those people were thoughtful. Both of them, Erskine and Senator Simpson, spent, along with the rest of their colleagues, an immense amount of time talking about the real pain and the real way to address it. And yet we passed it, and now we're going to pass something on to another commission. I do think and hope that we will take that out. I perceive it just as dangerous as putting up a balanced budget amendment and telling me, Mr. Chairman, that we're going to have one day to look at something that we don't know what it is. And you and I have been in this room many times with you on the other side and us on this side, me on that side when you were on the other side, and we've talked about not having an opportunity to see everything. I'll tell you how all of this is going to end up. We'll hit the wall somewhere during the weekend. They're going to say we need to be here Saturday, Sunday, and may be here Monday. And when we hit the wall, whatever that wall is, at some magical hour, a whole lot of stuff is going to come over here, however it is that the agreement is being struck, and we won't know, many of us that are rank and file members, exactly what it is that we are voting on, and it'll be 2 weeks, 3 weeks, 2 years before we know much of the substance of what's in the measure that ultimately passes. Now, let me make it very clear. Somewhere along the line, it needs to be stated here that what is happening in this plan that Speaker Boehner released that we are not being facetious, Mr. Polis and I, and Mr. McGovern, by calling it the Dreyer Plan, since it's blank, and I believe, Mr. Chairman, that we are proceeding under a provision that carries us into exceptionally treacherous water from a precedent standpoint by having a Senate measure amended by a blank House and not have an amendment being offered by a member of the House of Representatives. What most of this seems to be about is President Obama, and not so much about this nation. I heard the Speaker 2 weeks ago say in one of his proposals after discussions with President Obama that if we do, as the Speaker was proposing at that time, if we do that measure, Obama will get his debt ceiling and we will get our provisions. Well, you see, it's not Obama's debt ceiling. It's America's debt ceiling. And he happens to be the President of the United States. There were other presidents when we passed 73 times debt ceiling measures since 1940, during wars, after wars, during recessions, after recessions, during good times and bad. We've been here, and I repeat, I have voted to raise the debt ceiling 8 times, and never, never have we had this kind of fixation with any president. In my judgment, it's pure, unadulterated political posture. I might also point out that the very first page of this 2-step approach contains a full 5 steps, each of which themselves require multiple steps to achieve. So between the cuts, caps, balanced budget requirements, slashing Medicare and Social Security, and refusing to raise taxes of any kind, we're looking at probably, in this measure, 50 different steps. So maybe we should change the title to the too complicated approach to simply paying what we owe. Or if I can't count to more than 2, maybe I shouldn't be trying to fix the budget. Raising the debt ceiling is not about new spending. It's about paying the expenses that we've already incurred. My Republican colleagues may not like what we've spent our money on, unnecessary wars, tax cuts for wealthy people, and unaffordable drug benefits are a few things that I can think of, but that doesn't mean we don't have to pay for them now. It's nothing short of unconscionable that we're going to crash this economy unless this Congress forces those Americans who can afford it the least to sacrifice with the little they have. I had 32 voice messages in the congressional office that I'm privileged to represent this morning here in Washington, and I had 66 in the office in Fort Lauderdale and 12 in the office in West Palm Beach or Delray. And all of them were asking what happens to Medicare or to Social Security or to Medicaid. Now, they also want to know how they're supposed to pay for their drugs after their unemployment insurance runs out. And we all know that there ain't no significant new jobs in this country right now. But I didn't get one message this morning from any millionaire or billionaire wondering what's going to happen to millions of Americans when we continue eliminating the programs that provide affordable housing, affordable health care, accessible education, and unemployment insurance. We talk all the time around here about the American people. Well, I'll tell you what they deserve. The American people, the credit markets, Wall Street, and the entire rest of the global economy need us to get this done. Not get half of it done today, and as Mr. Van Hollen says, come back here 6 months from now with the exact same people on both sides of the aisle saying the exact same things, creating yet another crisis, largely because of an election in 2012. Whatever we do, we don't need 50 steps. We need just 1 step, like we've done 73 times, as I mentioned, since 1940, and that's raise the debt ceiling and move this nation's business without complicating measures and creating all sorts of antipathy and disgust among ourselves and the American people. Thank you, Mr. Chairman.
Mr. Woodall.
Mr. Chairman, thinking I could cool down a little bit after that. I just mean to tell you, when Mr. Van Hollen, you said the very worst thing about this was that two-part program where we're going to do part of the debt ceiling today, part of the debt ceiling 6 months down the road. I'll tell you that's the very best part of the program. That's the only part of this program that has any interest to me whatsoever, because you're right. I wasn't here when we wrote all those unsigned checks in the past, and I have no interest in signing any blank checks right now. To have folks sit and suggest that, well, I agree with actually what Mr. Hastings said. It is about President Obama. He could absolutely have pushed Simpson Bowles and didn't do a thing. It is about the process. We've had the process on this has been junk. It's been absolute junk. You know where we had good process was on H.R. 1. You want a fully debated proposal? We had that on H.R. 1, and it went where? To the Senate and the White House to die. You want good process? We had that on the budget that we worked on together in the Budget Committee, that we worked on together on the House floor. Full, open debate and process. And you know where that went? Nowhere in the Senate and at the White House. There has been absolute good process when the time was right to do it right, and there has been no leadership from the other side of this Capitol and from the White House on any of those issues. Not one proposal. Folks have lots of things that they're against, but not one proposal that they are for. And that's why, sitting out here a week from August 2nd, you're right. All we're left with is bad process. Because we've got 7 days to avert calamity in this country. We could have averted it by fully funding the year in February, and we didn't. We could have averted it by agreeing on a framework for appropriations bills in April, but we didn't. And now we're stuck with it. And I just, pardon me, could not be prouder of what the Speaker has done to open up this House to good process. Now, I don't think that everybody recognizes good process when they see it. And I don't blame folks because they hadn't seen a lot of good process over the last, not just 4 years, but 6 years, 8 years, and 10 years. But we've had it, and it has gone absolutely nowhere. And here we are. Now, we're facing two choices here. We can either go ahead and make these decisions, all those programs Mr. Hastings talked about, we can make those decisions in the next 72 hours, or we can avert calamity on August 2nd and take the next 6 months to do this in a more open process. Take the next 6 months to treat these serious issues, which I would argue have already been treated seriously in February, have already been treated seriously in April, have already been treated seriously as we've passed half the appropriations bills so far in this House this year. Senate's passed no appropriations bills so far. But, Mr. Van Hollen, tell me this, and because I didn't hear anybody speak to it at all. You're concerned...
Excuse me, Mr. Woodall. There are very few people who have yet to record their votes on the House floor, and so we're going to have to recess at this moment so that members can go down and vote. And if you can come back, Mr. Van Hollen, we'd appreciate it.
Yes, Mr. Chairman. We'll do.
And then we hope that we'll be able to report this rule out when we're done.
Mr. Chair, after the votes.
No, we'll I think we should reconvene after the votes at this juncture. Yeah. So, committee's in recess. The Rules Committee will reconvene. We're here for further consideration of S627. When we recessed to go downstairs for the votes, we were in the midst of questioning coming from our friend from Georgia, Mr. Woodall. Before I recognize Mr. Woodall again, I'd just like to say that there was a little bit of tension in the room before we began, and so I took it upon myself, in light of the fact that I was concerned that we might be going to fisticuffs, to invite for the first visit to the Rules Committee our attending physician, Admiral Brian Monahan, just in case things were to get possibly out of hand at all here. And he did hear, by the way, I should say that there were...
It's okay, Doctor. I can take him 2 falls out of 3.
Yeah, well, that's why he needs to be here, because that is absolutely right. You're absolutely right.
Absolutely.
I agree with that. You can, and that's why I needed the doctor behind me, just in case you were to
Do shock treatment?
do that. And I will say that I know that I'm probably playing into the hands of my friends in the minority by saying this, but the doctor did indicate that he'd heard rumor that there were deep cuts, and he was concerned that we might actually get to the vein here at some point, and so he's here to not only observe, but to provide whatever assistance is necessary. And now, the chair is happy to recognize our friend from Lawrenceville.
And I yield back, Mr. Chairman.
Okay. We haven't heard from Mr. Polis yet.
Thank you. Indeed, I have something to say on the topic. First, I want to establish when we talk about getting rid of special interest tax breaks, I want to see if the budget ranking member agrees that with regards to kind of government engineering of policy, whether it's a special interest tax break or a subsidy on the expenditure side, obviously the two have some unique characteristics as they relate to nonprofits and non-tax-paying entities, but generally speaking, aren't they fairly economically similar if you have a specific tax break for something or a specific subsidy for something?
Yes, which is why organizations like the Bipartisan Fiscal Commission refer to them as tax expenditures, because it's a form of spending through the tax code, and so you should look at each of them on their own merits.
And in terms of, again, and many of my colleagues on both sides of the aisle know I've, been a businessman and am, proud capitalist and supporter of our capitalist system, and I generally look with some degree of disdain at all of these market distortions, and it sometimes befuddles me how my friends on the other side who pay lip service to supporting closer to a free market are staunch defenders of tax expenditures, of the very identical economic form of appropriation expenditures that they decry. At the same time, they call any effort to get rid of a tax expenditure somehow a tax increase. And yet somehow if we cut spending and a subsidy, that's a saving, but getting rid of a tax subsidy is a tax increase. While the two are nearly identical economically, again, sometimes there's different impacts on non-tax-paying entities like nonprofits, and there's reasons that each method is used in particular cases, but they both reek similarly of central planning. They both are a heavier hand of the government in the economy, not that they're always unwarranted. I think that there's some that members on both sides of the aisle, and even myself, support, whether they're tax subsidies for a strategic national purpose, like ending our reliance on oil through renewable energy or other strategic purpose. But again, there seems to be a very hypocritical way of looking at us from the other side. I for one, am upset that it's come to where we are here today. I think that we had I like to think, a great opportunity in this Congress. Instead of being presented with a bill that I know, to paraphrase some of the hyperbole in the last election, we're basically being told, pass the bill so you can see what's in it. If that sounds familiar to any of my colleagues, that's essentially what we're being told here in this case. And we still don't know what's in it. It's my understanding it might even be changing again, and we don't know about a constitution. Well, again, in some degrees, there's actually more temerity than my party and the majority even used with regards to a constitutional amendment. We did not involve for some sort of health care or Obamacare, there was never any constitutional amendment opposed. Those were all statutory changes. So again, pass the bill so you can see what's in it. I understand that's what we're being told. What is the opportunity here? Again, I think what makes sense here and what's being proposed and mischaracterized, unfortunately, when we're talking about tax reform, the President, the Gang of Six, the Simpson-Bowles Commission, none of them have advocated raising the rates. In fact, all three have advocated lowering the rates. What are the rates? The corporate tax rate, the individual marginal rate. Increasing the income derived from those rates by broadening the base, by getting rid of the special interest loopholes and the special tax subsidies in the code, and using some of that revenue to bring down the rate, and some of that revenue, and this is the key point that seems to be keeping the parties apart, some of that revenue for reducing the deficit. No one's talking about using some of that revenue to fund new government programs. In fact, there's cuts on the expenditure side. That's a given. Any deal. Obama, Gang of Six, Boehner, Reid, Bill Simpson, they all have expenditure cuts. That no one is saying there's not going to be expenditure cuts. They're there. The question is, how can we reform our tax code to get rid of tax expenditures to help reduce our deficit? I guess I would ask, again, unfortunately, there's not even a representative here from the majority party in the Budget Committee, but Mr. Van Hollen, why, in your discussions, deliberations on the Budget Committee, why are tax expenditures even being considered in a different way than appropriations expenditures?
Well, it's a very good question, Mr. Polis, and it's the point that we've been making. We've asked to have a hearing on exactly that subject, and I believe we are going to have a hearing sometime in September. We would have preferred to have it during this very important period when we're debating the best approach to the budget. But it does create, as you say, this sort of curious inconsistency, because I think we all would agree that if we identify a spending program that has outlived its usefulness or doesn't accomplish its intended purpose, we should eliminate it, and we can use those funds to reduce the deficit. Why that same principle doesn't apply, as you say, to tax expenditures is beyond me. If the goal is deficit reduction, then it's equally, you can equally, reduce the deficit by $1 by cutting an unnecessary program, or $1 by eliminating an unnecessary subsidy. Which is why it's so strange that in the proposal that would go to the floor, they would propose a constitutional amendment that says you need a 2/3 vote to get rid of a tax expenditure, a loophole in the tax code, for the purposes of reducing the deficit.
Well, and in this case, again, we're being told pass the bill so you know what's in it. We don't even know what's in this proposed constitutional amendment.
Would the gentleman yield?
I'll be happy to yield to my friend from Georgia.
I would just say to my friend that I'm a majority member of the Budget Committee. If there's anything that I can answer to be helpful, I'd love to be that.
Sure. Can you?
And if the gentleman would further.
Yeah, I'll yield to you in a moment. Thanks for offering, because I do want to pose a question to you. What is the economic difference between a tax expenditure, namely a particular tax subsidy for a particular form of behavior of a business, and an appropriation subsidy?
I would say to the gentleman, there's only one of us on this committee who's introduced a bill to abolish every tax expenditure in the code, and that person is me. And I have 62 of my Republican colleagues who have joined me to do exactly that. So it's a little disingenuous to suggest that folks believe tax expenditures are some sacred cow. I'm happy to do away with all of them, because I share your disdain for economic distortions across the board.
Yeah, well, I agree wholeheartedly with your dedication. Unfortunately, too many on your side of the aisle have made them a sacred cow and said, and somehow by getting rid of tax subsidies, that's a tax increase. I'm glad that you pointed out the distinction there, and again, your particular proposal has its merits. You and I have talked about it. I worry about the underground economy component of that, but it's an ongoing discussion I'm happy to talk about with you, because I think we do fundamentally agree that tax expenditures are expenditures in the same way that appropriations expenditures are. If you're telling a company you do this special little thing that some government official wants you to do, you get a tax break, you get a subsidy, I mean, it's the same dollars in the bank. And I mean, again, I appreciate your answer to that. Although, again, others on your side have somehow tried to draw a distinction between tax expenditures and appropriations expenditures, which is the topic of the debate here. Again, there's an opportunity, a great opportunity our country has here to do something together, something that would substantially impact the deficit. Mr. Van Hollen mentioned using the revenues from reducing tax expenditures to reduce the deficit, and I'd like to follow that up. Mr. Van Hollen, haven't yourself, as well as the President, as well as Democratic leadership, acknowledged that, in fact, some of those savings from reducing tax expenditures could actually be used to lower taxes, and some of them would be used to lower the deficit. I think, haven't we also offered up that, in fact, some of them might very well be can be used to reduce taxes?
Yes, Mr. Polis. I think there's widespread agreement that our corporate tax code is badly in need of fixing. If you look at the overall corporate tax rate, it is higher than most of our competitors, but if you look at the effective U.S. tax rate, because of all the loopholes, we're actually lower than a lot of our competitors. And so all those tax breaks, tax expenditures create strange economic incentives, which is why we agree that tax reform on the corporate side can bring down the rate, broaden the base, and at the same time, you can raise some revenue in the process. For this reason, this gets to Mr. Woodall's bill. If somebody comes in and is able to get an expenditure that we decide is unnecessary, we all agree let's eliminate it for the purposes of deficit reduction. If you have some special interest that comes to Congress and says, okay, give me a special interest tax break, our view is you should be able to eliminate that and reduce the deficit. The view that you have put forth in your Republican budget is if someone comes in here and gets that special tax break, the only way you will get rid of it, the only way is not for the purpose of deficit reduction, but by reducing the rate. And that's where the inconsistency is, because if there's a tax expenditure that is not justifiable on the merits, and some have policy justification, then why not just get rid of it for the purpose of deficit reduction and what we all see as our common goal to try and reduce the burden on our children and grandchildren.
And to follow up, I will yield to the gentleman from Georgia, and I'd like to pose a question to him, which is also what Mr. Van Hollen kind of alluded to, that I'd asked my colleague from Georgia whether he would support striking the two-thirds vote requirement in the balanced budget amendment to eliminate tax expenditures.
Well, just to clarify, Mr. Van Hollen referenced the Republican budget. The Republican budget has no such proposal in it, the House-passed budget. You mean this constitutional amendment? Yes. That we're talking about, and I'd be happy to, if someone could clarify that for me, but there is no constitutional amendment that we're talking about at this moment. We're talking about passing a rule that allows for a suspension bill to be brought up later in the week, but there's absolutely no text that you need to read to pass before you know what's in it.
Well, again, there is. It's right here in this orphan bill that perhaps Mr. Dreyer has adopted. The vote on the balanced budget amendment is Title II, Section 201 and 202. And there is a balanced budget amendment on the Rules Committee website. We don't know if that's the version or not we're going to pass.
What's to be debated in September and October? That's the Section 2 that you're reading there?
Will the gentleman yield to me?
Yield the gentleman from Massachusetts.
My understanding is that the rule is going to allow for a balanced budget amendment to be brought up this week, right?
If whoever has control of the time would yield to me, I mean,
and the one that's
I don't know who's controlling the time.
The one that's
whoever has
printed
the time, I'd like to be yield if they might.
on the Rules Committee webpage does exactly what Mr. Polis is saying. Now, if you're going to give him an assurance that whatever we're supposed to not believe that may or may not be the one on the floor.
So if somebody would yield to me, I'll give an explanation.
I will. I'll yield to Mr. Gower.
But if you would agree in principle to what Mr. Polis has said, I think that might satisfy everybody right now.
Okay.
And I'll yield to the chair.
I thank my friend for yielding, and let me just say that we're not here discussing or debating. There's no provision in this rule that we're considering that has anything to do with a balanced budget amendment, other than to say that if we have a vote on a balanced budget amendment, we are going to extend the amount of time for debate because it will be considered under suspension of the rules, meaning that this committee would not even consider that measure. And so we have a provision in this rule which states that unlike the traditional 1 hour of notification that is given for the consideration of measures to be brought up under suspension of the rules, we will provide 1 day, at least 1 day, notice for the consideration of that. But again, this rule has nothing to do with a balanced budget amendment, other than to say that if we have a vote on a balanced budget amendment, we will extend the amount of time beyond the traditional 20 minutes per side for consideration of measures that are brought up under suspension of the rules. And I thank my friend for yielding.
I yield to the gentleman from Massachusetts.
And forgive me for being a little bit confused here, but on the Rules Committee webpage where it says legislative text to be brought up this week, and it has a version of the balanced budget amendment that has caused us some concern. I mean, I think one might anticipate that that might be the real deal. Now, maybe it's to throw us off so that, we go down one road and it might be something entirely different. This is why this process, Mr. Woodall, is broken right now. This is why this is not a good process. When you're talking about amending the Constitution of the United States of America, you ought to know what the heck we're doing before you bring it to the floor. And 1 day in advance, I don't believe, for something this important, is adequate. I yield back, Bell's right.
I thank the gentleman, and as the gentleman from Georgia knows, and other of those who support a constitutional amendment for a balanced budget, we know we need support from both sides of the aisle. That was the wisdom of the founding fathers. It requires a 2/3 majority. I've said in the past that on my journey, I've come to the point where I support a balanced budget amendment. I certainly don't support what is being passed off as a balanced budget amendment, which would actually write a specific percentage of GDP that constitutes government into the Constitution. Should the government live within its means? Absolutely. And I think you'll find that many in my caucus support that. Some do, some don't. There's many good economics reasons why it shouldn't be there, but to me the overriding principle why it should be there is I don't think Congress will do it absent that. And the truth of the matter is, and whether we acknowledge it or not, I think it could very well be some combination of revenue as well as cuts that leads to reaching a balanced budget. And again, that's not pleasant. Not that anybody likes that, but not having a balanced budget, I think, is worse than having something in our Constitution that may at times be difficult to have. So again, I think we have a tremendous opportunity here, and I actually have to submit to the record, I have asked unanimous consent to insert the record of the Statement of Administration Policy, which states the administration is opposed to this proposal, into the record. And I'll before closing, I'll yield to Mr. Hastings in a moment, but I want to say that the message from the President is that if Senate Bill 627 is presented to the President and senior advisors would recommend that he veto a bill, and somehow, by some, that's been portrayed as not a veto threat. I just want to say, in all the time I've been here, that's the standard language used whenever there's an administration policy. It says the President and senior advisors would recommend that he veto the bill. That's been on anything that I've seen that is a veto message. It doesn't mean that, people are saying, oh, he's trying to leave wiggle room. No, that's the boilerplate language that they send over on a statement of administrative policy for something that they oppose. And we've seen it a couple dozen times in this committee. There may be other language they've used on occasion too, but this particular language, verbatim, I've seen a number of times here. And before closing, I want to yield to my friend from Florida.
Thank you very much. I appreciate my friend for yielding. Mr. Van Hollen, just a quick question. Since we recessed, the Congressional Budget Office has scored the measure of Speaker Boehner. What is the implication of that at this point? We're talking CBO score versus what we've been yakking about here all afternoon or most of the day since 3 o'clock.
Well, Mr. Hastings, you're right. We have a letter we've received from the Congressional Budget Office, a letter to the Speaker that scores the Speaker's proposal, which we're discussing here today. And it says rather than 1.2 trillion in savings, it's $850 billion in savings over the 10-year period, which does raise the question about whether that means that we're going to even shorten further the amount of time that we allow the United States to pay its bills without facing another crisis. Because the biggest flaw in the proposal put forward by Speaker Boehner is that it builds in this instability and uncertainty in the economy at a time when we should all be focused on trying to get the economy moving again, get people back to work. Why in the world would we do anything to make a fragile economy even worse? And yet, I hope, only the majority can tell us whether what this means is they will make the fuse even shorter so that we're right back to where we are today, rather than, instead of 6 months, which is bad enough, during an even shorter period.
Can you make a copy of that, and I ask unanimous consent that it be placed in the record, Mr. Chairman?
Without objection, it will be included in the
And I thank
record.
the
And
gentleman for
Thank you. Reclaiming my time. Again, so what we're being asked here essentially is pass the bill so you know what's in it. Multi-trillion-dollar bill. Those are mind-boggling numbers. Punt the ball down the road for any real solutions, and create uncertainty in the short and medium term in our economy. The world and the markets have seen us go through this exercise, and they're not terribly impressed with us. And if this bill were to become law, we would be going down this road again in a matter of months, and the markets in the world would know that. It's unfortunate when the solution is apparent and within grasp. It's been articulated by bipartisan group of senators in the Gang of Six. It's been articulated in the Bowles-Simpson Commission. Not that any member of this committee in particular might agree or disagree with all the things in those reports, but they fundamentally tackle a real problem, and to be fair, a medium and long-term problem, which is our budget problem. So, again, not only are we kicking the ball down the road yet again and avoiding the difficult decisions, but we'd be sending a bill to the President, which would be vetoed by the President, a bill that we have to pass to know what's in, with a constitutional amendment that somehow, under its current form, treats tax expenditures different than subsidies, and is almost entirely lacking of the bipartisan support that we all know could be achieved with a common sense solution, and one that I think would be well within the grasp of this body and the Senate, and something that could be signed by the President of the United States. And I hope that this body rises to that challenge. I encourage my colleagues on both sides of the aisle to do the right thing for the country, not the right thing for a party, not the right thing for a moment, but the right thing for the United States of America. And I yield back the balance of my time.
Thank you very much, Mr. Polis. Mr. Nugent.
Thank you, Mr. Chairman. Once again, I agree with Mr. Polis at the beginning of his comments on the balanced budget. I think that's something that there's a number of us that believe strongly that that's the only check and balance that seems to work up here. We've had a number of pieces of legislation have come through that have capped our spending, but guess what? This body, not Democrat or Republican, but this body has the propensity to, once the crisis is past or things are running smoothly, to get back on the spending bandwagon. And I truly believe that, we're sitting here with a spending addiction. But my question, and I know Mr. Hastings mentioned about, voting for a debt increase. Have you ever voted against the debt increase?
I have, Mr. Nugent. I voted against the debt increase on at least 2 occasions. On the most recent vote, I voted against the debt increase, as many of you did, for a different reason. It was unprecedented that some language was inserted into that debt increase that said that we have to raise the debt increase as a result of President Obama's policy. It was frankly, and I think most people would agree, a blatantly political statement and not accurate either. I think all of us know that we have to raise the debt ceiling for any number of policy decisions that have been made, and the biggest drivers of those policy decisions were made before the President took office. So that was the most recent.
Would my colleagues yield just one moment? You're absolutely correct, and thank you for calling out my remarks regarding voting on the debt ceiling. What I meant was, and I misspoke, was that I have voted 8 times on a debt ceiling. I have also voted against raising the debt ceiling. And I thank my colleague for bringing that.
Well, it wasn't meant as a call out. But, it's interesting, though, when you look at the statistics behind the votes for a debt ceiling, for and against, it seems to always be, a partisan issue in regards to whomever is controlling this body tends to vote for the debt increase, and those that don't vote against it. And typically, it appears that it is strictly driven by politics, and particularly for us and for the freshmen, we don't have a history. We didn't help create this debt issue, but we certainly have an obligation, I believe, to make sure that this country doesn't default and this country does move forward. And I think when you look back at it, the plans, the discussions that were going on between the President and the Senate and the House, I don't want to second guess it, but I believe that it should have been between the House and the Senate. The President has the ability to weigh in after something's passed. He's, in my estimation, is not a participant in the discussion in regards to how we get our house in order. So we got back to that point, and it would appear, things change. After there's agreement, there can be a pull away from that agreement. And I understand after an agreement's made that there's been conversation that would cause you to have pause and reflection and back away from it. But at the end of the day, and you've hit it, all of my colleagues have hit it, that we need something passed. We need true deficit reduction. We need it to get us on a sustainable path for the future. And I just don't, I see what the Speaker has put forward with a lot of thought. Now, what the Senate does, they haven't done anything anyhow, across the board. So whether they pass it or not, while important, it's important, I think, that this House speaks with a strong voice in regards to trying to do things just like you think raising the debt limits, you said it back in 2004, raising the debt limit is reckless to do that. I think not raising the debt limit this time would be reckless on our part. And so so as much as we talk, and the good thing about the balanced budget amendment is even if we pass it, and the Senate passes it, and the President, but it goes to the states to ratify. It takes no effect in law until the states ratify it. And trust me, that's not going to be done in a week. And you've talked about it. It's 2, 3, 4 years possibly, depending upon the time frame. And there will be ample debate in the states as to whether or not the American people really want a balanced budget amendment. And so that's what I'm hoping for, is that the American people get an opportunity to weigh in with their vote. And to withhold that opportunity, I think, is reckless on our part, because I agree with Mr. Polis. I don't believe that we may all have the ability to control our spending, but I worry about future Congresses having that ability.
Will the gentleman yield for a moment?
I certainly will.
Again, the way to get to a constitutional amendment that can get two-thirds in this body is just not this way that's being indicated here, where we don't know what the amendment is. There's one version on the Rules Committee. It may be it. It's to have a bipartisan agreement and work out what's the balanced budget amendment going to look like. I can tell you that the current version on the Rules Committee website, again, in their last incarnation, I think it got 4 or 5 Democratic votes. It needs a lot more than that. Right. It could be a simple balanced budget amendment. There's a multi-year version one. I sponsor a version with Mr. Amash. There's a Henry Cuellar version. There's a number of them floating around out there. Not every Democrat's going to support them. We don't need every Democrat. Perhaps not every Republican is going to support it. But this process is not one that leads to a balanced budget amendment, if that's the goal, and I'll yield back.
I thank you for your comments, and I yield back.
Scott. Question of Mr. Van Hollen. Is there a balanced budget amendment that you would support?
That's a good question. What I've said is I'm happy to engage in that debate. I think it's not the way It's not
Let's
the way.
forget about the no's, because we've already adopted the party of no. So you're a party of yes.
Yeah.
And I'm wondering which yes.
I'm for reducing the deficit and putting us on a trajectory to balance the budget. I think it is the responsibility of the Congress to do it. The issue with constitutional amendments are primarily twofold. What you do in times of war, what you do in times of an economic emergency. You want the United States government to be able to respond. In addition, I mean, this is a long and complicated conversation. For example, at the state level, you know, we often hear the states have balanced budget amendments. 49 out of 50 do, although I should make it very clear that very few have the provisions that would be inserted in this proposal, the two-thirds requirement and the 18%. But even that being said, states have capital budgets where they do borrow. I mean, states float bonds all the time. They borrow money for the purpose of school construction and roads and all that kind of thing. The federal budget is designed very differently. We're on sort of a pay-as-you-go. We don't have a separate capital budget. So there are big and complicated issues that need to be discussed as part of the design of any constitutional balanced budget. And I will end with this, and this gets to let's say you pass a constitutional balanced budget. How is it enforced? The judiciary? The reality is, at the end of the day, it's all up to us. If we can't do something like what the Gang of Six did or what the Bipartisan Commission did, we don't have any recourse. You think a judge, a federal court judge, is going to tell you when you exceed the spending limits in any provision that you're going to raise revenue or you're going to make cuts? People don't. There's a whole enforcement part to this. It's really easy and very popular to say, I'm for a balanced budget amendment. But tell me how you're going to enforce it. It's got to be forced to the judiciary. This is a political question. And that's why if we can't get our act together and recognize that everybody's got to come off of some of the issues that they've dug in on, points they've dug in on, we're not going to be able to solve this problem. And I don't think a balanced budget amendment does it. I'm happy to talk about it to see if you can address all those issues. I haven't seen one design that addresses all those concerns.
Well, I just have one comment about the enforcement. You swore, as I did, to uphold the Constitution. That's pretty much it.
I did, and it does not have this amendment in it right
But
now. I like it
if
just
did,
the way it
there
is.
would not need to be an enforcement because your oath would be that.
I swore to uphold the Constitution. I didn't swear to support every, what I think, crazy constitutional amendment idea that comes along to the Constitution.
Any further questions? Mr. Van Hollen, thank you very much for being here.
Thank you, Mr. Chairman.
Appreciate it and look forward to consideration of this measure. Everyone has a copy of this letter from the Congressional Budget Office. We are going to recess subject to the call of the chair. There are going to be some discussions taking place. I can't tell you what time that'll be. Within the next hour and a half, hour to hour and a half, we're hoping that we'll be able to reconvene. So the chair is in, the committee is in recess subject to call of the chair.
I've not.
So is it 8:15 yet? Oh, no, we're still early.
Got to keep those things busy after school. Oh, we sure got trouble. Right here in River City.
The Rules Committee will reconvene. Thank you all very much for understanding. This has been a challenging day and challenging time for all of us as we deal with the imperative of ensuring that the country doesn't go into default. And we began by considering the the measure from the Education and the Workforce Committee. And let's begin by receiving a motion from the gentlewoman from Grandfather Community, North Carolina, Ms. Fox.
Mr. Chair, I move the committee report a closed rule for consideration of H.R. 2587, the Protecting Jobs from Government Interference Act. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and the Workforce, now printed in the bill, shall be considered as adopted. The bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit the bill with or without instruction.
You've heard the motion of the gentlewoman. Let me just say at the outset that we did not want to have a closed rule. We were hoping to have a structured rule, making an order amendments that have been submitted to the committee, as we've done in the past. We received a single amendment from a Republican, and that amendment was non-germane. And we heard from the testimony of the ranking member of the committee, my California colleague, Mr. Miller, that in light of the opposition from the Democrats to the legislation, they chose not to offer any amendments to the bill. And so we will proceed with considering this under a closed rule, I suspect. The gentleman from Worcester.
Even though that both Mr. Miller and Mr. Andrews said the Democrats wouldn't offer amendments, I would think that this would give you an opportunity to be able to offer an open rule for the first time on a non-appropriations bill. So, I hope that.
Are you offering a motion?
No, I'm not. I'm just saying that this would have been the opportunity for you to offer an open rule.
Well, thanks for that thought. It's very helpful. Let me just say that, are there any amendments to the rule? If not, the vote occurs on the motion of the gentlewoman. Those in favor will say aye. Those opposed, no. Opinion share. The ayes have it. The ayes have it. The motion. Clerk, call the roll.
Mr. Sessions. Ms. Fox. Aye. Ms. Fox, aye. Mr. Bishop. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Nugent. Mr. Nugent, aye. Mr. Scott. Aye. Mr. Scott, aye. Mr. Webster. Yay. Mr. Webster, aye. Ms. Slaughter.
No.
Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Pohl. Mr. Pohl. Mr. Polis. Mr. Chairman.
Aye. And how's Mr. Bishop recorded?
Mr. Bishop is not recorded.
I think Mr. Bishop probably wants to vote for the rule to be recorded.
Mr. Bishop, aye.
Clerk report the total.
Increase the debt ceiling.
7 yeas, 3 nays.
And the motion is agreed to, and this will be managed by Mr. Scott, gentleman from North Charleston. Is going to be managed.
And Mr. McGovern for the minority.
And Mr. McGovern for the minority. Let me just explain, as we discussed when we were together earlier, we have the report from the Congressional Budget Office, and everyone knows when you're dealing with an issue of this magnitude, trillions of dollars of spending, and our quest to ensure that we comply with the pledge. We're working on that right now, and so we are going to recess this evening, and we will hope to reconvene tomorrow. We'll adjourn this evening. We've taken the testimony already, and we will convene tomorrow at some point. We don't have a time set yet, but we will look forward to an opportunity when we can come together and, again, ensure that the package that we have is in full compliance with the pledge that we have. So thank you all very much.
Mr. Chairman, I
Yes.
just wanted to say that we were pleased. We wanted to know if we were going to be called back this evening.
Nope.
We are
No one will be
pleased that
called
we
back
are
this
not.
evening.
Do you foresee any time certain when this?
As I say, we'll let you know tomorrow. We'll let you know tomorrow. It'll be obviously sometime during the day tomorrow, we hope, and so we'll certainly give you, as always, the the 1 hour's notice before we have our meeting, and we'll look forward to doing that. Yes, you can. Yes, you can.
Is it this because of the CBO score, or do you?
Yes. No,
Or do you anticipate pulling the bill
It's-
entirely?
No. This is to address the concern that was raised with the Congressional Budget Office scoring that had the 850 level, and we're working on that right now to ensure that we completely address the concerns that are out there and comply with the pledge.
So it'd be wrong to infer that there was a more moderate position that was emerging.
I don't know what the gentleman was talking about. I would say that this reason that we're not reporting the rule out tonight is that the Congressional Budget Office scored this at 850, and when anyone's dealing with a measure of this magnitude, obviously there are serious budget implications and issues that need to be addressed. And our wonderful team, Mr. Halpern et al., will be working in the next several hours to ensure that we are able to address this and fully comply with the pledge. So without objection, the committee stands adjourned.